So this matter will be taken after the vacation.
Any interim order?
No, this is the first case.
Under prayer of this motion?
Yes, Your Lord.
Okay. Under prayer of the learned counsel for the petitioner, please this matter after vacation.
Highly obliged.
My pleasure, Lord. Item number 11, my lord. There is failure on the part of my lord to annex the plain mile. Kindly take it up on Wednesday, my lord. I'll file it.
You offer, you will withdraw it or file it or additional.
Additional evidence.
Mr. Secretary, learned counsel for the petitioner submitted inadvertently a vital document, that is
Plain.
plain of a suit is not annexed with the petition. Accordingly, he prays for a permission to bring that on record by way of an additional affidavit. Prayer is allowed. This matter
When
on Wednesday.
obliged.
Maybe if I beg to mention listing of bail matter regarding
Bail or allowed, bail or
I have.
bail all allowed,
Please,
but not today, huh? Tomorrow, yeah.
I beg to mention item number 9.
Item number
90.
tomorrow, day after, as per you just mix it. Item number?
90.
Yes,
So kindly pass over that.
please this matter after vacation on the prayer of the Radical.
Your Lordship, I beg to mention for listing a criminal petition. It was
Go to the
part of
senior bench.
Item number 46, Lordship. Time for the information. We have filed our written objection today, Lordship. Let me be called for. We have filed our written objection today, Lord. Time for the information,
Retains objection in bail.
Lordship.
Culture, new culture, developing. I cannot.
Yeah.
Permitted. Do you think that we will go through your written objection and not go to the case diary? It has come.
CDS comment. Correct. There is bar also in detail submission.
But what is this? I do not. I'll have to. Will stop filing all this. Whatever you want to assist, you assist. Yes.
Board 39 April. Well, I am behind
Ten
the
copies. Translated.
My-
From.
here, my lord, Kamrup
Please give the case number and the code.
case number, my lord. Already it has been called, my on the last
Not
public. I think wrongly listed in motion.
Okay.
Nine.
Yes, not in
Registry in view of office note dated 12/10/2023. Registry to forthwith issue reminder and seek an explanation. Not necessary. Reminder for the scan copies, production of scan copies as directed by this court under its order dated 3/10/2023. Please. After
After.
give a date. Inside.
Well,
15. Scan copies.
my lord.
Scan copies.
Lord, my humble submission before your lordship, 67 days, my lord.
No,
And,
days is,
I-
after filing of 30 days is not important.
My lord, I approached before your lordship earlier,
Okay.
and your lordship directed to appear before the trial court.
Ah.
I approached the trial court rejected. Now I have before your lord.
I understand.
Not
But
that
what material have you
charge sheet has been submitted. So it is the first case. No. So my lord, my humble submission before your lordship, 67 days in custody. The charge sheet has been submitted.
Mm.
In the
No, we
first
understand.
My lord.
According to you, what is your requirement inside custody?
Yes.
Until and unless it is assured that you remain present and part of the
Yes,
proceeding.
my lord, trial will face.
Trial you will face, but to do that, we need some material. That is the difficult. Those materials, you are also not with you. The statement made against you because moment charge sheet is filed, the situation changes. It's not like an indefensible right. So we'll fix immediately on
No,
reopening.
my lord, supposing I admitting or your lordship's observation
Hmm.
that there is sufficient materials against me.
Hmm.
Then also, my lord, by keeping me in custody, no benefit will come.
Keeping you in custody may not benefit, may not come.
Mhm.
But what is law tell us? You enlighten us. What is the law? After filing of charge sheet, right of bail. Let us understand.
My lord, after filing of the charge sheet,
Hmm.
in my case, my lord,
No, not in your case. Let us get
my
enlightened.
lord, in my case, it bit separate matter because I approached before your lordship first. Then your lordship
Hmm.
found that charge sheet has been submitted.
Ah,
Then I was directed to appear before the trial court
Hmm.
and file a regular bail. That regular bail was rejected.
that we
Now-
understand. Because otherwise we could have granted you bail on filing of the charge sheet on the day itself. Here, why should have you send you to the trial court? Because after filing of the charge sheet,
Malab,
that
only point your lordship will consider, while my detention will benefit the case anyway,
from where do I consider it?
my lord. No, from the supplementary charge sheet,
Where are those? Where are those?
supplementary charge sheet is in record, my lord.
Where is that
Yes,
record?
my lord.
And where are the statements on the basis
FIR
of which-
before your lordship, that supplementary charge sheet before your lordship.
Vacation.
That
He's arguing,
supplementary
we'll have
charge
to-
sheet.
we'll have to give an audience. Decision is ours, but he's arguing, we'll have to give an audience.
Malab,
Yes.
only thing is this, my lord, whether my detention in jail custody will benefit
No, that
anything.
is not the only consideration. After filing of charge sheet, that is not the only consideration, if I am not mistaken. That's why I said enlighten us, what is the consideration after filing of charge?
Consideration is this, my lord, only.
No,
because-
law, don't
No,
go about your fact.
No, my lord, regarding law, my lord, I am submitting. Why people is kept in custody?
Hmm.
Why a person, a citizen is kept in custody? I am before the Honorable High Court.
Hmm.
Your lordship will consider the right under 21, Article 21 of the Constitution. Why people are kept in custody, man? Your lordship can consider that for the purpose, certain purposes. But here no purpose is there. Why my liberty will be curtailed, man?
Okay,
Is there any purpose to keep me in custody?
we do not know.
Malab?
We do not know, we'll have to see, suppose what is the offense?
Offense 302 added, my lord.
302, if there is a scope of threatening the main accused eyewitness,
My lord,
where do we get this?
your lordship,
What is your involvement? So let us,
12 persons named in the affair.
Hmm.
They were searched
Hmm.
in first search.
Hmm.
They all are on bail.
Hmm.
And subsequently, my lord, supplementary charge sheet against me has been submitted.
Hmm.
And that too, it is written that on the direction of the OC,
Hmm.
it is not mentioned in the supplementary charge sheet that there is materials against me.
Hmm.
But it is said that the Honorable OC directed me to arrest the accused.
so now
So
you
I have
to
arrested.
decide
I have arrested.
whether that direction of the OC is based on some material or not. We can get it from the city only. Is not it?
Huh.
Give us a handle. It hadn't been a stage of after CC. Then you could have annexed all this. I could have seen it.
But my lord,
But this is a case
my
of
lord, I humbly submit before your lordship. When Honorable High Court
Hmm.
and the Honorable Supreme Court,
Hmm.
these are two courts
Hmm.
in the country.
Hmm.
When consider regarding the bail petition, my lord, they are not concentrating
Hmm.
only on the technical problem. man.
not
They are
at all.
They are to
Not at
they are to
all. Not
consider
at all. Not
at
at
least
all.
High Court and the Supreme Court.
That
And in Supreme Court, in many cases, my lord, granted bail on the ground that detention is not necessary.
that
and prolonged
satisfies. Now tell us, we also pass
Prolonged
many
detention, my
orders.
lord, I have in 67 days in custody.
We have also passed
For
many orders, but
Okay.
there must be some basis of satisfaction. We cannot be guided on the basis of kindness or humbleness. we'll have to guide it by some basic principle. That is your bad luck. You would have come earlier before filing of the search sheet.
I came, my lord, in the meantime.
But in the
search it-
meantime, search sheet file, what to do?
I am trapped.
And this court at least will not hesitate, will jealously protect the right under Article 21.
Take it out of the vacation of the point. Then after vacation, my lord.
After vacation. And you have also come,
Yep.
when I have rejected, I have sent you to the trial court.
Your lordship, send it to the trial court, my lord, by order.
When?
I am placing, my lord.
15/9.
Your lordship's order.
Okay, call for the scan copies of the file of. Release this matter on
After vacation, my lord, and
give it
before
on
vacation,
the
it is
ring
not-
opening.
reopening 6 days, 6.
Again, it will not come on that day.
My lord.
May let it be on around 7th or 9th.
Yes,
Huh?
my lord.
9th.
9th. Our pleasure.
10 people. Equal. Several cases are fixed in the
Please, your lordship.
Swami,
loss.
have the instruction whether girl is recovered.
Loss.
Girl is recovered.
I'm for item number 3.
You
I'll
have
take
for
the-
item number 3, that
Three.
is why girl is recovered.
Oh, yes, lord.
Where is your statement?
This is motion, lord.
Done.
Oh,
Yes,
there is,
recovery.
we cannot allow bail in motion. Okay, call for the case.
Loss.
Have the instruction, he is 20, she is 15.
Lordship.
Have the instruction whether recovered will allow. Oh, is there any bar in allowing in the motion stage?
No, no, lordship.
If you do not want, then you can call for the case direct.
Lordship, the
Next,
accused
next.
petitioner is in judicial custody from last 16 days.
Time. We have some patience. You have been inside 60 days.
Lord, 16.
16. Have at least 2 hours. So Swami, have an instruction whether recovered will allow.
Lord.
Second time.
Second.
Why earlier you have not annexed the other fire?
That I annexed. But total page number 25 plus 3.
Huh?
Petitioner was severely, my lordship,
We have
assaulted
seen
by
that.
the-
That was not there on earlier petition.
This photograph was not there, but affair was, second affair was there. And our affair was the next.
Your affair is in an earlier point of time.
Mine.
I'm surprised why I rejected
Yes, sir.
this bill. There
I-
may be some mistake. Notice CD interim.
Obliged.
Intent.
You did it. You did this case
Yes, sir.
earlier.
I did.
I myself is surprised why I have rejected. Yes. Next case.
My lord, in item number 5, lordship. These two petitioner lordships,
You go and appear. Considering the nature of allegation as a whole, as well as the fact that petitioner is not named in the affair, CD interim.
During 23rd.
Yes, Mr. Sharma.
my lord, the main accused.
Considering that the allegations are primarily against the husband of the deceased victim, and the petitioners are mother-in-law and father-in-law.
The mother and father of the petition.
Mother-in-law and father-in-law of the
Yeah,
victim, mother and father-in-law victim, in interim. Appear and give
25th.
statement.
20.
CD interim.
Obliged.
It's a case of quashing. Who are you to do a foreign material? Goswami?
Yes.
Foreign original. You inform the central excise. Public. Give statement. Yeah. Considering the nature of allegation as well as the admitted intimate relation between the victim and the petitioner interview. Give statement. Did it. You are the only unlucky.
No, my lord,
You
I,
are the only unlucky.
no, I have a case of lucky.
Yes.
Kindly see the FIR,
Yes.
page 8.
Please read.
With due respect, I beg to state that,
That I have already read.
no, charges are against accused number 1. I am not
Ah.
accused number 1. Accused number 1 is, my lord, Phokor Ali, and I am Shafiqul Haq Chaudhary. So he went to police station and threatened. Now it is not believable. However, even then, for the sake of argument, even then, what? Just, I am not the
Considering
one?
that basic allegation is against
Even.
the accused number 1. Interim.
Hello.
Give statement.
My
Go and
lord, in
give.
all these cases, my lord, my submission that I have
No,
paid
that
for
is
the-
already there.
I have paid for the
I have recorded nothing.
I
That
have paid for the
it will start with heard Mr. So and so. This is a case under application so and so.
Right.
Your submission, then his submission, then
Yes.
my decision. My decision only I have done.
No. Okay. No. No, please, your lordship.
Why you apprehend? First tell us that.
My lordship, the police, because this incident happened surrounding to my areas, in 10 kilometers area of my village, my lordship. And that's why police are randomly
Then
searching
to
the
it will be difficult. There will be 10, 20 bail benches. If you are a resident of 10 kilometers
and my
and
lordship,
therefore you apprehend,
my lordship, kindly see the FIR, my lordship, last 3 lines, my lord. It's page number 9, my lord. Again, 5.
it's a dacoity.
My lord.
It's a dacoity or robbery.
But I'm not the
Nobody
passenger.
was, nobody.
I
Now
was
you
not-
expect that in robbery also people will name. Nobody is named. Why are you here?
My
Tell us.
lordship, my lordship, I was not there.
Nobody is
I
named.
was in Guwahati, my lordship. I have annexed the.
So don't, why, there is no apprehension.
My lordship, but police
Your
searching
first ground is that you were around 10 kilometers radius of the place where robbery was committed.
my lord.
And according to the FIR, all are masked. Nobody
All are
could identify anybody.
My lord.
Now you are here, so we apprehend that you are the culprit. Therefore, CD.
My lord, I have annexed the
You have invited yourself.
hotel records, my lord.
What record?
The receipt hotel paid. I was in Guwahati, my lord. So I was a contractor labor, my lord.
Why are you apprehending? I do not know. The police will not arrest you. Right?
No.
I'm surprised. Yes,
Yes.
next.
Character, prototype.
None appears to a petitioner on call.
Perhaps 53 earlier, so it is better.
Hmm.
I can
CD. CD. When?
little this type. Also, time being allotted.
Why?
Actually, because January is coming on the way election. It's arguing with case election.
J. Ahmed is
It's coming on the way.
on the way. What is the case? Tell us first.
Well, to mention.
Passing off?
Yeah.
What?
Actually, I'm not angry.
You are not in the case.
Case election. But it,
Okay, time being. What is this, Mr.
There was
Kukan?
a 144 proceedings which stood concluded by a judicial order
Ah.
whereby the private respondents there did not appear.
Hmm.
Subsequently, 3 people who are completely not related to the proceeding goes ahead, files a criminal revision, and the matter is now being proceeded to be reverted back on that same proceeding, which is already stands closed by a judicial order. The people who were initially present before the proceedings have
So
not come in the civil revision.
these 3 parties went to the original court or to the
No.
higher court?
Straight file a
Straight to the executive magistrate.
Yes, and file to the stage called filing a criminal revision against an order which closed my 144 proceedings. A detailed proceedings where the party is available. there.
Where is the order in your favor?
Yes. Would your lordships come to page 118? May I just tell your lordship, there are two kind of things has happened. I am actually an owner of a 64 bighas of land.
Yes.
The proceeding started with an FIR that was filed
Hmm.
in regards to saying that there has been an encroachment in my area.
Hmm.
So 2 areas were identified. The first area is 20 acres of land, where a 144 proceedings were initiated initially. Then an application was filed under 145, 146, attachment orders are passed. So for both 15 and 26, there is a conclusive evidence that I am the owner of the property for both.
Where is
15
the
and-
findings? Your
Yes.
possession?
Yes, your lordships will come to page 118. That is the order that has been passed, closing the 144.
118. I am at 118.
118. So would your lordships come to 10 lines from the top? It says on the day the first party prayed for filing written statement that was allowed. The second party, however, did not take any steps. The letter that the written statement was filed. However, the second party, that is the party in proceedings in that
That
proceeding.
proceeding.
Yes, did not take any steps. However, the second party did not file a written statement or took any steps. So the case was fixed for evidence and the first party alone filed the evidence. This is my evidence
Hmm.
on regards to the 4 persons on 22. The case was then fixed for 17 for cross-examination of the said witnesses. But this time also the second party members did not attend the court and they did not file any petition asking for time. That is the evidence of the parties. Therefore, the arguments were heard and therefore subsequently an order was passed. The conclusion in regards to both the areas are at page 124.
124.
Yes. It says, considering all the above, I am in a definite view that it is the first party, that is me, who is entitled to be declared to be a possession of the disputed land on the day of the order, and accordingly, I declare the first person to be in possession of the disputed land until evicted therefrom in due course of law.
Yes.
I also forbid all disturbance into the first party of the possession until the eviction happens.
Now who
subsequent-
comes?
Now, your lordships will come to the revision, the criminal revision at page 125.
Who files this?
There are 3 unknown people for the litigation. They are not even a part of the first FIR. They come and say that the order is bad, which closes my 144
What,
proceeding.
how they declare them to be the
Yes, your
interested
lordships will
party?
come to the ground that they have taken at page 128. They say para 2 that the above named petitioner is a lawful possessor of the disputed land, whereas opposite party 2 has not endorsed any of the land document along with the complaint petition to prove their ownership. My ownership is already proved. There's an order passed by the Lot Mondal Revenue Office and an inquiry report also filed that the 64 acres of land belongs to me. Of an absolutely unknown people come and file this petition.
What is the schedule of the land?
Yes, the lordships will come to page 124 again, that the order that was passed. Now, I'll first,
Just a minute, just a minute. just a minute.
the main schedule is that the 144 proceedings, your lordship, that was filed. That's at page 42.
Your schedule is land measuring 15 bighas.
That is the first part, the second part.
Okay.
So the entire part is 64.
Yeah.
Encroachment first happened on a 20 bigger. Attachment order passed. Subsequently, again, another FIR 15
So
bigger.
a disputed land is 15 bighas. Where
15 and
LS
20.
15 and 20.
Yeah, so both the orders are here. The first order and the second, the 15 and the 20 biggers is at 124. Oh, sorry, that's at 121.
One 21.
Yes, your lordship, the schedule of the disputed land.
Where
So land, absolutely at the bottom. Land measuring 20 bighas,
120.
121, your lordship. That's the order passed in regards to 144.
Okay, okay.
So this is 20 and that's 15. And 144 application speaks about that I am the owner of the entire 64 land. Even the Java Mandi and also the Lot Mondal reports. Is that.
Now who is this man? But how he declared to be interested in his petition, criminal revision petition?
He doesn't explain that. He only says that that I have not been able to prove my ownership rights. Therefore,
Why he's aggrieved? What is the statement?
where there's no statement to that effect to say that why is he aggrieved.
Where is his petition?
Yeah, that's at page 125, which is 6 of 2022, filed before the session started. He basically speaks about the case that has happened under 144, which was filed by one Sonowal, and says that in that case that has happened.
But he says that he filed an application on 1/4/2021 before the proceeding. Appeared before the executive minister at page 4. At page 127, paragraph 4. Kindly paragraph 4 and 5.
Yes, Your Lordship, I'm just saying that 1/4/21. He's appearance
That is his ground.
Page 77, Your Lordship,
Page
77. This is in the case of Bitupal Sonowal. Page 64. And if your lordships go to page 65, the 107 proceeding which is drawn up doesn't have his name. Only
No,
5
no,
persons have been
he
named.
says that I filed an application.
Yeah, but this application is only in regards to the Bitupal Sonowal matter. And only 5 persons were there. That is at page 65, which is the 107 proceedings which have been drawn up against it. Only 5 people name are there. That name does not reflect in the criminal revision. Page 65. I have annexed that.
You are Jiten Kumar Gogoi.
Yes, I'm the authorized, the manager. The names are Bitupal Sonowal, Dulu Roy, Babul Bora, Ramu Chetri, Santosh Chetri. These
So
are the
there
5.
are 2 proceedings.
Yes,
One is case number 12
yes,
and other is
35.
one is under 107.
Yes, that is at page 65.
Okay.
Yes,
And that order is at page
the 144 proceedings order, Your Lordship.
121.
Yes, that's 121.
121 relating to 107.
Yes,
And the earlier next order relates to.
the same, there were 2 lands.
Okay.
So they relate to the same 2 lands, 15 and 20 bighas.
RB Fukan, learned counsel for the petitioner, also Mr. Goswami, learned counsel for the respondent number 1. Full stop. The present petition is filed assailing an order dated 19/2023, passed in criminal revision petition number 06 within bracket 1 of 2022 by the learned citizen Just Tinsukia. Full stop. Tinsukia. The aforesaid criminal revision petition was preferred by the present respondent number 2.
4,
No, the aforesaid
2 to 4,
2 and 4.
2 to 4.
Respondent number 2, 3, and 4. Assailing an order dated 2 orders.
No, only one order, 28/2/2022.
Order dated
28/2/2022, passed by the learned Deputy Commissioner,
28
Executive Magistrate, sorry,
executive magistrate, that is page 120
125,
125.
case number 35 of 2021,
Assailing an order dated
28/2/2022.
28/2/2022.
Yeah.
In case number 35 of
21.
2021.
Yes.
By the executive magistrate Tinsukia,
Yes,
in a proceeding arising out of section 145 CRPC.
Yes.
CRPC. Full stop. By the order passed by the learned executive magistrate, the position of the petitioner was affirmed and the present respondents were not party to that proceeding. isn't it?
Yes,
Not party to the proceeding. In as much as it is a contention that the learned session judge in your interim order by session judge.
initially, yes, on 17/3,
Ah.
but that was culminated into the final order now, which has been passed on
come on.
19.
Whereby what is the order to remand the back? Remand back.
Yes, remand back.
Whereby declaring position in favor of the present petitioner. In as much as the said proceeded expert. Full stop. No revision was preferred by the parties therein. However, the present respondents were not party to that process in the proceeding before the learned executive magistrate had preferred the criminal revision petition. Consider the submission advanced by the learned counsel for the parties. Also peruse the material available at the court. Issue notice issue notice Goswami accept for one, for others register post with AD. Considering the matter in entirety, the status quo in respect of the
I'm extremely good.
land that is page 125.
125.
Page
No,
1
120, 121, your lordship, my lord. 121,
121.
yes,
This is the order
yes, the 20 bighas of land.
where he is not a party.
Yes.
Schedule of
yes.
the land. Status quo in respect of the likha tha, the schedule of the land. Page 121. Be maintained till the returnable date.
Great.
After 6 weeks.
Technically, I'm taking a say of my own proceedings that I filed and I'm the plan of the report. Grateful.
What is this?
My lord, the only thing is that, my lord, the impugn order of enhancement, my lord, because passed perhaps in ignorance with the settled law passed by the Honorable Supreme Court in Brazil for this Neha, my lord, and that was an ex parte order. So, my lord, I am before your lordship because that order was passed without calling for any
Where is the impugn order?
impugn order, my lord, at page 42, my lord.
Why Rajneesh and Neha is required if you don't appear?
No, my lord, this is an ex parte order.
You have not appeared.
I
You
didn't
opted not to appear.
No, look, I didn't receive a notice. I was in Cayman Island. I was in abroad. So I stayed there for my livelihood, man. And
In terms of dollar, it's peanut. Where are you doing a job? 10,000 rupees is a peanut.
no, look, that is not the question.
We are issuing a notice.
I'm
and,
still paying, my lord. I'm
you
still paying.
continue to pay and deposit 10,000 in the registry for her litigation cost.
No, my lord, this impugn order is of 20%.
Or continue to pay.
Exactly, extra amount.
10,000
No,
deposit.
I'm a waiter, a helper, my lord. In the,
Oh, waiter, most of the Indians are doing that and sending money to in dollar, transferring into dollars. 10,000, what is the total amount given, enhancement?
my lord, from 3,000 to 25,000.
It's nothing, peanuts. Notice. And deposit 10,000 before the registry for her litigation. Her litigation. Interim order shall be considered on the next returnable. Hmm. Yes, what is this? I have not
This is-
seen a single file today.
Discuss also the party order pass lottery,
Maintenance,
lottery,
how much?
8,000 from
What
labor,
do you do?
labor. Lottery
Notice,
only, lottery expertise order is there, warrant issue lottery. I somehow managed 2 installment lottery. I'm going to pay that. Kindly recall
don't
the
say kindly before this court. This court is
Kindly-
having no kindness
Lordship.
except law.
lottery.
Yes.
Lottery, warrant may be recalled, lottery. I may be allowed to pay.
How much area is due?
Area is little bit big lottery,
Till-
1,30,000 like
And-
that. But lottery, I'm a laborer lottery. I have filed a affidavit before the other court lottery in DB case lottery. Considering that part,
What is the total amount?
total amount about 1,30,000 like that lottery.
And
But lottery-
what is the current monthly?
Monthly kind is 8,000.
Pay the 8,000 without fail till returnable date. We are now no coercive action for non-payment.
No.
Okay, then we'll consider and deposit something. Who will pay the lawyer's cost?
No lottery, he cannot pay lottery. He is
No.
in the court below.
No. We are inviting your wife to here.
Oh,
Who will pay her cost to coming to this court, paying money to people like Gothakar, H.R.A. Choudhury?
but she has engaged lawyer in DB case and under.
That's why she had to spend some money
Kindly see the
subject to deposit of 5,000 additional for her litigation.
present 8,000 and
Pay 8,000, you continue to pay her and 5,000 deposit before the High Court registry. You do pro bono. He is a labor, so better you do it pro bono and whatever has been given, deposit it. Huh? No coercive action shall be taken against the petitioner till returnable date on non-payment of the arrears of maintenance. However, subject to the condition that the petitioner shall continue to pay the monthly awarded maintenance. Okay, cost we are not given. Okay, let us see. It is to be noted that if the respondent wife is not able to engage any counsel, this court, she may approach the legal services, Guwahati Legal Services Authority Committee for appointment of a legal aid counsel.
warrant may be warrant
No coercive action should be taken.
obliged.
But you subject to, you
Payment.
continue to pay.
Obliged.
Yes, my lord, my case is also related to maintenance, my lord. The standard court below has awarded maintenance of rupees 8,000 per month, my lord.
8,000,
Per month, my lord, to the wife. My lord,
only
Sir.
8,000.
my lord, one for
What-
some
What do you
person
do?
it is only, but in my case, my lord, it is huge.
Huh?
In my case, it is huge, my lord. For some other persons, it may be.
What do you do?
My lord, he has a rural pharmacy, my lord. Wherein
Rural pharmacy.
pharmacy,
Oh, there
Lord.
everything is sold.
my lord, no, my lord, kindly come to.
Rural pharmacy, we know it.
My lord, and the family. of the
Everything and what not. Even the pharmacist becomes sometimes doctor.
My lord.
No.
Lordship, my lord, the family is under BPL category, my lord. The BPL card is, my lord, ration
We'll
card.
ask to enquire the government to whether you are under BPL and we'll to verify the BPL category.
My lord, that will-
Okay?
Yeah.
Yes,
That-
thus, we want an inquiry by your CID, whether his BPL or BPL card is. Yes.
Lordship, the BPL card is in the name of the respondent herself, my
Respondent, so she's
My
under
lord-
BPL.
my lord, yes, my lord, while he was currently living with me, my lord. That's why, my lord, the 8,000 amount.
What is the amount? 8,000. What
Yes,
do you
sir.
do? You have a local pharmacy. Now tell us how much area?
No area, my lord.
No area.
Somehow I could manage. my lord.
Continue to pay and deposit 10,000 here
My lord,
for litigation cost.
my lord, that may be
Or
possible.
do it after vacation.
Then after vacation.
Ah. Yes,
May I please your lord?
what happened to Aisa?
My lord, petitioner before your lordship is seeking some protection, my lord, in various order dated passed by my lord, additional session judge NBW has been issued against her, my lord.
What was the offense you committed?
Offense is under section 370-34, my lord.
Hmm.
I was after receiving the summon, I was regularly, my lord, appeared before the trial court. That
Hmm.
lordship may kindly peruse at page 26, my lord.
Then
Thereafter, my lord,
why you have not appeared thereafter?
lordship, that is why I'm
Huh?
that I am submitting, my lord.
Hmm.
Thereafter, my lord, Corona pandemic period came, my lord. In that period, although I
That
was
corona is a problem.
lordship,
Yes, then
thereafter, my lord,
did
I was not
did
entered
not
to allow
do any corona.
my lord
Yes,
inside the
then
court. Thereafter, my lord, NBW has issued against me, my lord. I lost the contact with
when
my
corona was over?
My lord, in 2021, my
21.
Okay, we have
Very well.
given up. Thereafter also we have that. What happened? Side effect of corona.
Side effect of I was not allowed, my lord. Although I appear, my
Side
lord,
effect, lung infection.
my lord. So, my lord,
Where is your statement? Reason, explain, which paragraph?
my lord, I am. My lord, paragraph 7, my lord. Page 7.
Reason.
Reason, my lord, I'm the petition, lordship.
Don't make this kind of statement.
Lord.
You see,
Eh.
don't make only for client's sake, don't make this kind of statement, paragraph thing. Read paragraph thing.
The petitioner most respectfully begs to state that petitioner was appearing regularly in every date before the learned additional sessions as number 1 prior to before COVID pandemic period.
Hmm.
But the learned court did not take personal appearance on account of Corona pandemic.
Hmm.
And HHC have not appeared.
Okay, fine. Up to that, fine. Then read.
It is worth mentioning herein that she lost contact with her engaged counsel,
Hmm.
illiterate layman.
Okay, then
And moreover, she has been misinformed that the learned court had closed down her case due to pandemic. Since she is an
who informed you? Who informed you that your case is closed?
my lord, illiterate, it is some.
She is illiterate, we understand.
Some, my lord,
But the person who has drafted it is not illiterate, I suppose.
lord,
Who advised her? The learned court or the lawyer? Who advised her?
whatever, my lord, she explained before me, I have written.
You'll have to ask who informed you that your case is closed.
I asked, my lord, some strangers, my lord, she told me.
Where is the statement?
I am
that
extremely
the
sorry, my
stranger?
lord.
Why she will believe the stranger?
Lordship, I'm extremely sorry for that, man.
Don't do all this. These are not good practice.
Obliged, definitely.
Don't do all this.
I will not repeat,
Don't do this.
definitely.
Give proper explanation. That yes, I could not appear. I did not have money. I was suffering. Why? Somebody told her that her case is closed. Therefore, she did not.
I'm extremely.
NBWA shall remain suspended. Paragraph 7. Under text, paragraph 7. Disposal.
Deeply obliged.
he will appear.
Still appear.
He'll appear.
Still appear. Yes, Ali, what is this?
Lord, this is not for quashing of parallel proceeding, my lord.
What parallel proceeding?
My lord, out of same incident, my lord, 4 FIR was lost, my lord.
Hmm.
And 3 has already been amalgamated.
Hmm.
1 is independently, my lord, proceeding in Nalbari, my lord.
What is
And-
the allegation?
Allegation regarding my lord, question paper leakage case in SI examination, my lord.
Is there any bar if separate incidents are there?
My lord, here in the charge sheet, my lord, lordship kindly see, 3 cases were already amalgamated, 104, my lord, in the charge sheet.
Where is the case in FIR in this case?
FIR, my lord, page 18. First FIR, my lord, page 15,
Just a minute.
second FIR, page 18.
First FIR page
18, my lord.
page 18. You want to pause this?
Already charge sheet has been submitted. In the first case, my lord, charge sheet
Just
submitted,
a minute. This is 25/9/2020.
25/9.
And where is the other FIR?
Page 15, man.
Page
15 on 5.
Page 15 or 17?
That's not page 15, page 17, page 17 related.
These are two different cause of action.
Now, page 44, my lord, in the charge sheet, my lord.
Hmm?
Page 44, first, kindly see.
Yes, 44.
Page 44.
Yes.
Disclosed during investigation, my lord, then in the middle, my lord. 44. 144, my lord.
Page 44, yes.
144,
Yes, 14.
144.
Yes. 14, yes.
Lord, if the process of investigation,
14 is your affidavit.
144, my lord,
144.
144.
Yes. During process of investigation.
During the process of investigation started immediately and without losing the time, the suspects involved in the scam were apprehended and information was received that many of the suspects involved in the infamous SI exam question paper leak scam had either escaped, arrested, or in a rush to flee.
Who filed this FIR?
This FIR was filed by one
No. That your FIR page.
page 18, my lord.
17 and 18 are one is
17 is the original.
yes, sir.
Where the whole question paper leak.
Yes, sir.
Here it's a demand of money.
Yeah, demand
Different thing.
different.
And deal. Yes, tell us.
The accused is apprehended and the house was searched for more evidence. During search, a lot of incriminating evidence were recovered, which further led to unfolding of more episode of the infamous SI exam paper leak scam 2020. During investigation, it is revealed that name of the apprehended accused so-and-so has also been propped up in connection with the crime branch PS case number so and in linkage with prime accused of the accused so-and-so. It has to be mentioned that in the SI scam, question paper scam, in total 3 numbers of cases were registered. At first, keeping view of the gravity of the crime and magnitude of the involvement of the criminals in the criminal enacted, the cases are registered. First one is CID, my lord, that was page 17.
Hmm.
Then crime branch case was also registered, and Nolbari case was registered, my lord, and one Deepu case was also registered, my lord.
Yes.
Except Nolbari, my lord, all 3 cases has been already been amalgamated, and proceeding is going on in the special court, my lord. Charge sheet has been submitted, already 16 witnesses has been examined. I am one of the accused there also, my lord. And out of
Where are these two FIR? CID PS and crime branch PS.
that FIR, I have not.
That is
It
vital.
was mentioned in the
Because in view of Lalu Prasad judgment of Honorable Apex Court, individual causes of action, they can proceed. Other scams. Some scams were in this treasury, some were in under that treasury. Though as a whole, it was a further scam, Supreme Court says you can have independent trial, independent.
Now, my lord,
Here is a case subject to what the PP says, or we further verify.
Lord.
The CID case is basically paper leak.
Yes.
There are some accused. I had the occasion to deal with the
bill, yeah.
that voluminous
Yeah.
application. Allegation of leaking it through Silsar in somebody's hotel. That is the larger conspiracy. Here is a individual demand of money to give job.
Now, in the FIR, my lord, I am no,
Yeah.
in the FIR, there is some person name. I have been shown arrest in this case because I was accused.
No,
in
you are the
CID
main
case.
accused in the other
CID
cases.
case. That's why, my
You
lord,
are
I
the
have-
main person.
Lord. And already, my lord, two person, my lord, in CID case, as well as in Nalbari case, approached this Honorable Court. And this Honorable Court has protected them, my lord, case 178 order. Case 170. 178, my lord. He is accused number 3 in CID case, my lord. I am accused number 4.
What is the effect of this order? Tell us.
The proceeding has been stayed, my lord, in subsequent proceeding.
Subsequent proceeding
In Nalbari case against this petition.
what happened to it? This is still pending.
Lost.
So that proceeding is stayed. Entire proceeding is
No, my
stayed.
lord, in respect of particular accused. Is 180, my lord, and another order.
I have reservation anyway.
Lord.
I have reservation.
Only
And-
notice,
and-
my lord.
And discussion in both the
this-
charge sheet, my lord,
Huh?
same, my lord.
At this stage, only notice.
What notice? You have already on the similar ground relying on TT Anthony already stayed. Now whether the same cause of action. In
I mean,
my view, these
this
are two
cannot-
separate things. Separate things. Anyway,
In that count, my lord, can it be taken tomorrow, my lord? For tomorrow, I will go for the what
okay.
Right.
Tomorrow, day after tomorrow.
day.
Go through.
And in
Li-
both the
list-
charge sheet, my lord, narration is there.
No, understand.
What?
List this matter day after tomorrow along with. Let us open the box. Along with criminal petition 118/2021
And one,
and
330, case 181, my lord.
what is this? This you have already approached. Isn't it?
No, my lord.
What
It's
is
another
this?
accused.
That is Rokibul, yeah,
Hello.
Robiul.
Hello.
Along with
Yes.
criminal petition
What?
380/2021. Bring Lalu Prasad Yadav later.
Lord, Lord.
Latest, my lord, Arnab Kumar Dushmi's case, my lord.
Huh.
You know,
You will see
Supreme Court-
Arnab Kumar Goswami, Lalu Prasad Yadav will see. Fariduddin, what happened?
It is a lottery,
Yes,
it's active for the day.
for the
Day.
day is difficult. For 4 days we can adopt.
Lord.
What is the prayer here? These are all civil disputes.
Yeah.
List of application on the prayer Salan account. Immediately after reopening, give it. Take a more. Yes,
Lordship, 482 application, Lordship, for quashing a FIR, Lordship. Sanmari PS case number 141 of So the allegation is under section 306. The affair was closed totally on suspicion.
We'll see the case diary. Otherwise, there is no case of passing. Why should you enter a specific allegation against?
No, there's no prima facie because I was relation with the lady, the affair was lost again.
We'll take it up in motion. Mr. That's all the case diary.
Notice may be issued.
No. Reach this matter on after the. In the meantime, the learned official and public prosecutor can obtain the case diary of
Almari PS case number
Almari
141.
PS case number
141 of
141/2023. Registered under section 306 IPC, dated 16/4/2020.
my lord.
Yes, Mr. Sururi.
The petition was approach your lordship for watching a criminal case and the charge sheet.
Hmm.
Your lordship may kindly first come to the FIR. The translated FIR is at my lord case 36, in particular at 39. I did see my lord translated.
Then
Your lordship may come to the bail order,
page
page 41 and 43. 41 is my lord in respect of
just that.
page 41. On 28/2022, informant Bitu Burman lodged an affair stating that the local
Page,
people page 41. Next step. Your lordship has read the FIR. Your lordship finds the the allegations therein. On 28/2022, I'm reading the second paragraph.
Yes.
Bitu Burman lodged an affair stating that the local people could not bear things coming out from Bora Livestock Pig Farm. And on 28/2023, local people went to Bora Livestock to ask manager Amritan Rastogi to take necessary steps to stop this thing. But Haritansh Rastogi and one lady sprayed poisonous thing and also tried to attack with hammer and also took out 2 guns from inside and tried to kill. Accused also tried to molest the village ladies and abused with obscene language. Villagers, namely Devadip Medhi, Nikumani Burman, Arati Burman, and Lipika Burman, sustained injury. Heard learned special PD. There is the case diary. It is found from the case diary that IO has recorded the statement of the informant and statements of other 9 witnesses. The IO seized 1 iron hammer, 1 rifle, caliber 0.22 ARMR, 1 self-defense pepper spray.
You have not filed any affair.
My lord, the petitioners were arrested and my lord in the custody and they could not, my lord, lodge the affair till
They are released.
till their release
Then they file page 60.
at page 6.
Page.
Now, your lordship will kindly
Heard
come to-
Mr. M.K. Choudhury, learned counsel for the senior counsel for the petitioner. Also heard Mr. Leader, learned Additional Public Prosecutor. Present application under section 482 of the Code of Criminal Procedure 1973 is filed for quashing the proceeding in PRC case number 725/2023 arising out of Mukalmua PS case number 219/2023 under section 341, 325, 326/307/294/34 of the Indian Penal Code. Peruse the case FIR lodged by the respondent number, respondent number 2, as well as the FIR lodged by the present petitioner. Also peruse the order of bail granted by this court.
Granted by my lord,
Granted by the learned court below.
special judge.
The learned special judge granting bail to the petitioner. Considering the matter in entirety, this court is of the view that this matter needs further examination. Accordingly, is to notice returnable after 6 weeks. Mr. Task for 1 states in respect of 2 to registered post as well as to Israel mode. Registry to call for the scan copies of the proceeding of PRC case number so and so, including the case diary of so and so PS case number so and so, till further till the returnable date, considering the matter in entirety. The further proceeding in PRC case number so and so shall remain suspended.
Matter of fact, 54 and 55 same,
Yes.
all the different petition of mine. Your lordship will find complaint on page 29, mile. This is regarding about the banking. So this respondent number 2 has borrowed some money from the bank.
Hmm.
And his case is, my lord, we have made an agreement that there will be no nil foreclosure. But ultimately we have charged it. Now, what criminal offense, my lord, I started your lordship kindness from the FIR itself, fine.
That's
Nothing is,
HDFC Bank.
yes, my lord.
HDFC Bank.
And already further.
That you have taken a loan. The
Not I-
doctor has taken a loan.
Right.
Now the doctor says that there was no due for. This matter was listed earlier also.
Yes, last time it come, but because I was late, my other court, so your lordship.
Okay. Hard.
Already similar order is page 79, ma'am.
Page
79. Another person came, ma'am.
same order.
Same order.
Both the cases. Name will be different.
Yes, name will be different point.
File.
Same my lord, item 55.
54 and 55. Notice it.
Obliged.
List along with A2T. Yes, Bhattacharya. What is this criminal petition before vacation?
Central government a party or
Something was there, na?
that your lordship sanction point of
Sanction is required.
we have served them copy. Although your
Name so
their name
Not sure.
not shown.
we'll take a day after tomorrow.
Lordship, I will not get
Where are you going? Tomorrow?
tomorrow.
Tomorrow. List this matter tomorrow, showing the name of ASCI and as well as senior government advocate state of Assam. Registry to list this matter tomorrow, showing the name of ASJ, na? What is now?
Assistant Solicitor General.
Yes, something different now. DSG.
No, Deputy Solicitor General.
Deputy DSGI for Union of India as well as senior government advocate state of Assam in the constitution.
Problem.
Here, two information we have received. One is my card is recovered, but third sheet has also been filed.
Oh dear.
Right.
Can you have the number?
Yes, my lord. Third sheet number 73 of
You are
the
so fast in filing charge sheet in these cases.
Yeah.
And where necessary, don't file 20 years, boy, he will be inside. All these are
Yeah.
emotional.
Uh,
Anyway,
73/23 dated 7/10/23.
7, 10, 20.
Amit.
Wait. Just subscribe.
Yes, ma'am.
Just subscribe. Okay. Approach there, then come back to us. If not,
Yes.
motion or what?
What's all right? What is it? No, I mean,
You say somebody has to be. If says name is shown, reflect the name. You are for the
We are,
petitioner.
Asian also sees it.
Okay,
J-
acha.
petitioner, madam.
Okay. What is this?
But in this case,
No, prayer. What is prayer? Crossing of the fire, crossing of
no. Instead of the order passed by the executive magistrate in a 145 proceeding, my lord. Without hearing me, my lord, our land has been going to be attachment. They passes the land, we also passes the land, and the respondent, he passes the land, he already.
Why don't you go to the executive magistrate and say that vacate this order?
My lord, in the meantime, if attachment has been made, we will be suffered. That is, I will go there.
Attachment not passed.
Not yet, attachment order passed, but till today it is not executed. But they are
You
giving
will
the.
also say that status quo in respect of the land should be maintained.
Because, my lord, originally they mentioned our name wrongly. That is why we have not received any notice, my lord.
Hmm.
Now,
Where is the impugn order? Tell us.
impugn order is illustrated is page 28. My name wrongly mentioned, my father name wrongly mentioned. Now we come to learn today, yesterday they corrected the name by filing a petition. That is why order has not been executed. my lord.
Third, Satya Ahmed. So third. The present petition is filed assailing an order dated 31/8/2023 in by executive magistrate in a proceeding under section 145 CR
145/146.
145/146,
Case number 172 of 2020.
which was registered as
Case number 172M
Hmm.
2020.
okay 172M on the 2022. Also, basic difference of the petitioner is that the petitioner is still possessing uh, possessing the land, and while filing the aforesaid case under section 145/146, the respondent has intentionally given the wrong name of the petitioner
And his
and
father.
their father's name, and therefore no notice was served and the matter proceeded ex parte.
Notice,
And-
there's a notice, sir. What is the notice? But we will
but,
not appear.
mm,
But we
without
will not receive
serving,
any receipt.
serving any notice to them, though it was reflected in the order that notice has duly been served. Mr. Ahmed further submits that further states that a fraud has been played upon the learned executive magistrate, and accordingly the learned executive magistrate has directed an order of attachment so far relating to the disputed land which is given in the as Schedule A. Okay. So Schedule A. Mr. Ahmed further contends that they are in possession of the land and there is no apprehension of any breach of peace and tranquility, and if the ex parte attachment order is allowed the petitioner shall suffer and shall be prejudiced. Considering such submission, let the notice be issued to the respondent. Mr. Boru accepts notice on behalf of respondent number 1.
My lord, there is no, they are not party.
Not but okay. Accordingly, let the notice be issued to the respondent. Steps to be taken. Considering the statement averments made in the paragraph and as well as considering the arguments advanced by the Ahmed, by Mr. Ahmed, this court is of the view that till return of notice, the status quo in respect of Schedule A land, which is described in the impugned order dated 31/8/2023, be maintained.
And if not executed, it will be
Maintain and maintain, that's what.
hello.
Status in respect of the maintain and land shall not be attached if same has not been attached in the maintain. None appears for the petitioner on call. So Mr. Borua, R. Borua, learned additional public prosecutor is present. Case diary has also been received.
No, my lord, it is my lord, first the case notice, then copy was called for.
Scan copies called for has also been received. However, the present application is the scan copies called for has been received. What to do? It's a case for bail. It's a case for bail.
But may fix it after tomorrow, Thursday.
Why should we take burden? This man is inside, lawyer is not present. She specifically stated that we went together, I had a love affair. The accused says that I was at my residence. She called me that her family is torturing her. And she came with me. Her 164 statement that I went with him. Almost in the verge of majority. Please stop the petition. However, in the interest of justice, matters can adjourn and release thereafter.
Yes. What happened in the application, my lord? It
Who is
was
the
called
lawyer?
for.
Tell us. Some lawyer's name we should mark it. Write down. We'll mark some. Is it a way? When there is a motion, everybody will be here. Suppose he might have been granted bail by the court because nothing materials are not here. Mahmood, you are here.
27,
27, is it not your case? Mondal or Mahmood?
Mahmood.
27. 27, no, sir. Oh, my lord, actually, I do not want to disclose. If I disclose, then the client will be in trouble. So let me not to disclose.
Bail already granted. Tell us that.
Granted by lower court, but case is here pending. So that's why, my lord, they have also
It is
not.
submitted that in the meantime, the learned trial court has granted. It's a case of bail. Unnecessary discussion file. You should come and say that.
No, that was.
See our predicament. A person is inside jail.
Yes.
We found that it's a case for bail. We cannot pass an order. The lawyer is not there.
No, actually, that was argued many times. Lord, kindly see the last order.
Whatsoever.
Yes.
That
Today-
which is there.
Today,
We
when I-
have seen it. It's a case of bail. Girl went on her own. She's almost measured.
they have
Might
to-
be measured.
my lord, they have to also taken the file from me. That's why, my lord.
You should come and say that. At least we can.
That was informed, perhaps. It is recorded, perhaps. Kindly see. It is perhaps informed. So where I remember.
Abdullah's name is shown.
Ah.
Everybody is interested in where the instruction is there. Huh? Nothing survived. Mr. Mahmood submitted. Bail has already been granted by the learned trial court below. Accordingly, nothing survives to be decided in the present bail application. Accordingly, instance growth. After vacation, will take action. And Abdullah is not his name. He appeared, I think, after you. He's not here today. Moment there is a motion, there is a bail hearing, he will rush to here.
Yeah, please, Your Lordship.
Yes.
Case diary was called for matter 302 matter.
Did you do two, Guru?
Case diary received, Lordship, only postmortem report not received.
What is the allegation?
My lord, FIR, my lord, page 8.
When are you arrested?
My lord, arrested on my lord 3-8, my lord, 75 days and suspect my lord totally. My lord, page 8 is the FIR.
She was found. For any eyewitness?
Yeah, my lord, there are, my lord, already materials collected by the investigating officer against him. Lord. Because he was the person, Lordship, last, he was with the victim, Lordship. Then, Lordship, the
And
victim
what
in the
is
morning.
other circumstances
My
except
lord,
last
he had a, my lord, extra matter relation with the, my lord, victim.
victim is a married?
No, unmarried.
He is married.
He is married.
My lord, 2 years, my lord, working in a stem dump. Stem
His
under-
wife may be also involved. Why will he kill if he is having a married life and a girl? What is his problem? What are the other evidences? Because it's a body was found near a road, so there is no eyewitness. Only
Yes.
circumstantial evidence.
On the
His-
circumstantial evidence on the
when was last seen together?
in the last night, Lordship. In the
Previous
morning,
night.
she was found dead.
Previous night they were together.
Previous
Next night, how many witnesses you have? What is the
Around-
stage of investigation?
night. Investigation to collect the postmortem report. Lordship.
What you suggest 75 days?
Only my postmortem report I am. Only
Otherwise,
testimony.
otherwise you are pinpointing him.
Yes, Lordship. Otherwise,
They-
there are material, prima facie material is there. I will not say the absolute
Because
material.
my lord,
but-
we are, my lord, we are working in the same dump, my lord, under same, my lord, owner, my lord. That is
But
why,
circumstantial. Anyway,
Madam?
considering the period of detention and the stage of investigation. আরো একটা দিবাও Peruse the case diary produced. The investigating officer has thoroughly interrogated the petitioner and also examined witnesses. Examine witnesses. The in stage of investigation here, investigation is at an advanced stage. Considering the material in entirety, including the period of detention and stage of investigation, this court is of the view that no further custodial interrogation will be necessary. Accordingly, granted to the satisfaction of
city of Kamrup,
Kamrup
Metro, Metro.
Metro.
Hello.
39 bill application method. Today is 53 days.
That's why we called the city.
Yes, my lord, and to the
City was called on, we were arrested on 26/8.
25, my lord, 25 and forwarding my lord on 26. 8. And this is a suicidal case, my lord, anti.
Registered under 302.
Yes.
Material.
My lord, the-
Suicide
the
or
postmortem
murder?
report, Lordship, antemortem hanging, Lordship, but there was some my lord, injury found, Lordship, that is caused by blunt force impact, Lordship. And he is the my lord person against whom the my lord collected sufficient matter.
And my lord, we are the brother and mother of the main accused, my lord. We are not.
Who is main accused?
Many accused, the husband, Lord.
Husband, but
So what is their role
No,
attributed?
they also, my lord, used to instigate the main accused, Lord, and used to
Instigate.
quarrel with the, my lord, victim.
and today is 53 days.
The husband, allegation is against husband. He used to be.
Husband, mother, brother-in-law, and mother-in-law.
There are how many petitioners are there?
Two, my lord.
Brother-in-law and mother-in-law.
Be there for something.
At least, my lord,
Injury mark is there. Otherwise,
at least, my lord, mother may be considered, my
Lordship may
lord.
take it on
that
the,
is the difficult.
If there is no other person.
List this matter on the prayer of the learned additional public prosecutor. List this matter on 31/10/2020. Vacation. Are you here? 31/10/2020. In the
After that-
meantime, the postmortem report, we prayed it.
My lord, after that,
After vacation, okay, we'll go home. Okay, give a date after vacation, early date, huh?
7-11, Lord.
7 in.
of like,
Postmortem report, huh?
302, my lord, registered under section. My lord, petitioner behind the bar 113 days, my lord.
Are seated.
Yes, my lord, first case, my lord. My lord, there is, as per the, my lord, first case, my lord, there is no specific allegation against me, my lord. Four accused
Mr.
already-
Borua, can you go through this? 10 copies has come.
Yes,
Use
my lord.
10 copies.
My lord.
We'll take up when.
We'll go to the lord, whenever lord, will, my lord, please.
Today?
Today, sir, today, two, my. At two, my lord.
Whether any, whether main evidences are examined or
Yes.
whether it can be.
Well, that is not started.
Yes,
Trial not started.
Huh?
Trial not started.
trial not started.
It will
What will
start
see?
from-
Charge sheet file.
That-
Committed.
No, my lord, it's committee state. Notice only been issued, my lord.
302.
Yes, ma'am.
Why have you come here at this stage?
My lord, I'm, my lord, my lord, but my bill was rejected. ma'am.
No, that will definitely be after charge sheet presented. You should ought to have waited for the.
My lord, four accused already been granted bail, my lord. Even four were granted by the JMFT, man. My bill was rejected by the second court, my lord. That's why I'm before this honor.
Why rejected? What was the ground?
My lord, they stated at that time, my lord. rejected
Have
the
you,
first-
are you having the other bail order?
It is in the LCR, man. I found.
Okay, Borua, go to it.
Alright.
One, if others are given, then
My-
what is his implications we'll consider.
My lord. But, obliged.
May I please?
Yes.
Well, the picture is a lady.
Hmm.
And, my lord, she has 5 years
No,
old
no,
minor child.
no quota here in granting bail.
Right. Well, the candidate comes to the FIR. She was arrested on 4/9/2023. Today is 43 days, my lord, she is behind
What
the
is
bar.
the allegation against her?
Allegation is that, my lord, the informant saying in the FIR that his sister and the present petitioner went to the present petitioner's uncle's house at Ohio. And my lord, next day when she returned, then the informant asked repeatedly her his sister, then
It is there.
Yes, there is.
What is her age?
My lord, her age is 31.
And he?
Sorry, I'm sorry. Victim age is 31, Lord.
Ah.
And my lord, my lord, accused petitioner, her age is, my lord, 27, Lord.
What is the allegation?
Allegation, Lordship, in this present petitioner, Lordship, she took the victim to her, my lord,
Victim is 31
31,
and
as party,
and-
my lord, is
and the accused is
27.
27. So she took her to prostitution or what?
No, she took her to one, my lord, neighbor, what, a relative house, Lordship. Then they stayed there. Then the victim, she, my lord, she made some accusation that she was, my lord, sexually harassed, Lordship.
Harassed.
By the some person in the, my lord, wherein she resided.
Now, what is the link between
She took her to their house, Lord.
with
is-
intention?
My lord, that is not there, Lordship. Even it's 164 statement, Lordship, followed, yes, my lord, money implication, that is not
Anything
there.
that she introduced or she pushed into a, who are those people?
Those people are the, my lord, persons where they reside. They also reside, my lord, in the same house, Lordship. They are sons of the, my lord, the owner.
And what is the relation between that family and his client?
My lord, there,
Uncle,
what is state Rusuf from one word is state, that is, my lord.
Okay, your two friends went to uncle's house
yes, ma'am.
and uncle's son, your
have-
cousin misbehaved her.
It
Not
may be
misbehaved,
because,
brother.
it was
Physically
not
assault,
disclosed,
brother.
ma'am.
Huh?
Sexually abused.
Sexually,
It was not disclosed that house, ma'am, because I was not aware. When she came,
definitely, how can she went to your friend's
If-
relative
if, my
and
lord,
she was done all this.
if something happened, my lord, the president petitioner is not aware. When the
No, no,
girl,
we thought that is not, that may be the case. We are
My
not.
lord, some Gusti Khabo বসলো, what is Gusti Khabo?
Gusti Khabar you are, you will not understand, we will know that.
That is a,
They went to somebody's relative. We used to do this. Karam Bondha. Maternal uncle's place. You take your friend also, chalo, this time let us go to.
in their house also, she was one
Ah.
of the.
So he let her go.
My,
Peruse the statement record of the victim recorded under 164 statement as well as the case that considering the material available against the petitioner, his court is of the view that no custodial, further custodial interrogation is enough. To the satisfaction of
my lord, Cesium Bongai,
KCM.
I'm glad.
But other accused will have to make it clear. However, the allegations are basically against the cousins of the present petitioner.
Yes.
Let us record it so that
I'm
future
okay.
we do not forget about it. Yes, next.
May I please, doctor? Doctor, this is 439 bail application.
Hmm.
The Satgaon case. Case section 169/2023.
Hmm.
And the section 326 has been. Lordship, before coming to the FIR, Lordship, I'd like to ask a question. Actually, Lordship, this accused is a citizen of
Just give me a minute. FIR is at page 12.
case 8,
It
Lordship.
is there.
It is received, my lord. This is 5 between 2 Bokot.
One case, I think there was a, where I have seen, I do not know. There are some cases where masjid.
Yeah.
Who will control the God's residence? And they are fighting. I have seen some cases
Yes.
today. And now this is Bokot. Those were mullahs, now it's Bokot.
Injury is simple.
Okay. Hello. To the satisfaction of
Kamrup Metro.
that case. Why two ABs?
One murder is not arrested.
Hmm.
And his son has been arrested for
What is the allegation against murder?
similar murder. Similar would be petitioner murder.
Yes, what you say?
Eight, my lord. Is 68, my lord.
Yes,
68, my lord. My.
Of?
You know, it's 68, my lord. My objection.
what is the CD says? First
My
letter.
lord, yes. My lord, I have to one, my lord, I would not vote. My lord, I would.
First, because he will have a first right of audience. Then we come.
My lord, he committed suicide, lord.
That
The
is
case has been raised under section 302. Lord.
Hmm.
And my lord, investigation is going on, my lord, but my lord, the investigating officer said that case is going to establish under section 306 IPC, lord.
306 is prima facie. I am also of you.
And my lord, whatever material, lord, there are some, my lord, disputes with the
Extra
husband and
merit.
wife, lord.
Extra merit.
Yes, and my lord, there is another guard involved, lord. Against whom, lord, there are some, my lord, materials that the deceased and the my lord, that guard, lord, they have some relationship. That may be the cause between the husband and wife. Lord.
And
Because-
what is, but he alleges that the wife is having a relation with somebody.
Some body means some mother guard.
No, wife.
No, wife, yeah, somebody, that may be a girl or that may be a boy. Maybe a case of lesbian, I don't know.
But
That is
we
my-
doubt it is a case of lesbian, perhaps. And that was intimated to her father.
There's some other mobile clips are also, my lord.
I've seen.
That
I've
is there.
seen.
My lord,
Who
when
is that late girl with whom she
Mother-
was having
Her-
girl or boy?
her name is also.
Some Rimlita.
Rimlita, Lord. Her
Why
statement
did-
also recorded, Lord.
Her statement recorded.
Recorded.
What is her statement?
But she said that, Lordship, we have a close relationship, Lordship, since long. But she is younger to my lord, the victim. But this is Lordship.
And what is the statement of the husband?
Husband's statement is too long, Lordship.
Okay, you tell.
Please-
Mother's involvement is ruled out.
Please dictate, my lord.
Yes,
Please
I
dictate.
don't have your objection. Give a copy.
Milord,
Are you having?
yes, I have.
My husband, my lord, had a relationship with one girl, my lord.
Uh-huh.
With one girl.
Who was having a relation? This lady?
Yes.
Okay, then
Please dictate, my lord.
this relation is friendship or beyond friendship?
Probably beyond.
Okay. Then,
Please dictate, my lord. That communication, my lord. WhatsApp communication.
okay, that's he has also an. You get hold of her and then you saw everything. That while maintaining a married life, he was he caught. You are for whom? For the mother of the girl.
The informant.
For whom? For the informant is the mother of the
No, my lord. Father.
father. Okay.
Now you don't see. I thought. Please stop, my lord. Please 67, my lord.
Page 67.
Yes, my lord. Mr. Comfort that.
Just a minute.
Ali, my lord.
Okay. Shankar is he was maintaining a relation. And your daughter was also maintaining it. If we believe this, we'll have to believe that also.
My lord, that's fine. That is different, and my lord. Don't think it's not something. My lord.
Okay,
Now you're-
everything has been collected by
Can you please dictate?
Yes.
Please dictate, my lord. Will not speak loudly, man. Please dictate. MM and next line. Right and right. My lord. The plot is, my lord, this video. My lord. Can you right and side now?
Okay, this
We have-
happens
we-
sometimes.
We have my lord complaint. My daughter complaint. Getting this. He visits me, my lord. He sometimes-
It may be a cause of her suicide. Maybe a cause. But having all sympathy for the girl, it could have separated herself from the boy instead of separating herself from the whole world. Because these are nowadays the question of privacy. Somebody maintaining some relation, that can be a ground in a judgment of Honorable Apex Court to say that it is absolute privacy thing. Criminalization cannot be attributed on if it is consenting. Number one. Number two, that can be a ground for a divorce for a husband or a wife. A husband is not having an absolute right over the body of his wife. She is having her own person. If she maintains some relation or the other way, it can be a very good ground for a divorce, not any criminal.
My lord, investigation.
Murder we are granting, and him also we have collected everything.
The investigation is pending, lordship, to collect the, my lord, postmortem report. Lordship.
That-
That is not, my lord, final due to non-collected receipt of the FSL report.
Milord, whether some is given or not.
Yes, given.
Grant.
Also hard that's not what assisting the current public file. Perus the case diary product which suggests the case under section 306, not under 302. Be that as it may, considering the period of detention and nature of allegation in the present petitioner, nature of allegation as well as the stage of investigation, which is at the heart of completion, this court is of the view that no further custodial interrogation of the present petitioner to be required to the satisfaction of. What you say,
So to the
Mr.
solicitor investigating. officer.
No. CGM Kamrup Metro. Nunmati.
Sahu?
Sorry, my lord, one,
Better concentrate on second appeal.
yes, my lord, AB is
Don't
there.
come here.
No, my lord, AB is there, that is why. that can be done.
Better concentrate on second appeal and civil division.
Because both BA and AB is there. because
Yes,
That is,
considering the
yes, sorry.
length of detention, what will it is
Sorry,
AP or BA?
That AB was
To the
also
satisfaction of
to the satisfaction of the CGM.
CGM,
Kamrup Metro.
Kamrup Metro. Please mention metro or rural because we have to correct orders, many orders. It will say Kamrup, we write it Kamrup, sometimes my lord, it's a mistake. Then in AB, considering the material so far collected against the petitioner, this court is of the view that no direct implication has been made against the petitioner, who is the mother-in-law of the deceased victim. Is that it?
No, the husband. In BA, he is the husband and in the other.
That's why I'm saying. Go to that bench, second appeal. Then in the event arrest. Any interim?
No.
Further no interim. Then is the conditions appear before the IU
Within 7 days.
Huh?
Within 7 days.
within 7 days. Three 326.
My lord, 307, 356, my humble submission, my lord, these admins are not there, my lord. Maybe a case of 325 or 324, my lord.
Case that is not with you.
My lord, this is today, my lord, third occasion, my lord. This is my lord.
How many days you are inside?
My lord,
AP.
Huh?
my lord, dispute regarding my lord, paternal partition of paternal property, my lord, among brothers, my
Badol and Nagesar. And Sumpi is the sister. You do not want to give property to sister or what?
No, my lord, 4 brothers, my lord.
Badal and Nagesar are brothers. I
Yes.
can understand.
Yes.
But who is Sumpi?
My lord, informant the wife of the younger brother, my
Wife of the elder brother.
younger brother. My lord is a lordship, my lord. Call for the state with injury report, my lord. In the meantime, my lord, because Puja vacation is there, my lord, interim may be granted, my lord. And my lord, if you lordship, my lord, find, my lord, there is element of 307, then my lord, certainly you lordship, my lord, take my bail, I shall not pay. But my lord, Ahmed Pension, there is no, my lord, element of 307 or 326.
Let them enjoy the puja. Mozumdar.
My lord, without the case diary, because earlier occasion.
Yes, earlier
But
two
the case
occasions,
there is not being produced.
earlier 2 occasions. my lord, today
Okay, 19. Let us have a chance on 19.
My lord, 19.
Assamese Mozumdar or Bengali Mozumdar?
my lord.
Huh?
Bengali.
Puja. On 19.
My lord.
Purva, just
My-
have the instruction and
My lord.
with the injury.
Yes.
What?
May I please, your lordship?
Yes.
Lordship, in this case, the petitioners are the relatives of the apparent named accused person.
What is the offense?
Offense is under section, my lord, 326, 307. And
Here,
perhaps, my
who
lord,
are you? Who are you?
my lord, we have the relative.
Osim Sutradhar and
We have, my lord, many, my lord, Oshim Sutrodhar, my lord, Oshit Sutrodhar, Amol Sutrodhar, Sachin Sutrodhar, Ajoy Sutrodhar, then Kajol and Ajit has been arrested, my lord, then Manoj Sutrodhar, Deepak Sutrodhar,
Subhas and Pradeep.
my lord. They are our relatives, my lord,
They are named.
their name. And They have been granted bail, my lord. They have been,
Page 7, what is page 7 in Excel what?
page 9, my lord.
Page-
FIR. FIR is the page 9.
Oh, Monos, that Monosa Mundi.
My
You have
lord,
granted bail to some,
my lord, two FIR name request person.
huh?
Granted FIR name.
My lord, actually, subsequently the victim
Died.
died.
Hmm.
And these all petitioners, except all petitioners are named, my lord, subsequently. There are statements, my lord. And it
You
is
have
received,
grant-
but along with, not with the PM report. My lord.
Are you on interim?
No, my lord. The FIR name request person has been granted. We are relatives, my lord.
My lord, they all are present there at that time. my lord.
No, no,
5, 6 and 7 was already arrested.
my lord.
No, bail granted after arrest. This is a B.
No, no, my lord. While I have filed the petition, my lord, thereafter these two persons has been arrested because the police could not apprehend the FIR name request person.
Now we'll decide today.
My
What
lord,
is this?
with Subhas, Ajit, and Pradeep,
Hmm.
NBW was issued.
Now tell us, what is the material against this petitioner?
My lord, actually, initially 3 persons were named,
Hmm.
and the witnesses also stated that because that is a mob.
Hmm.
Puja, this immersion was going on, and they all are applying these
Alar.
colors and all these things. So once few persons stated some person's name, subsequently wife also stated some person's name. In while going through all the statements, my lord, all these petitioners' names came. In fact, few ladies were also involved, but they were not named, my lord.
How many applicants here?
My lord, here
9.
9, my lord.
Now, accused number Ajit Chutradhar already arrested.
My lord.
And who arrested?
Kajal, my lord. 6,
6 and all arrested.
6 and 7.
You also go there. Then we'll give you on the day 1 after.
My lord.
You also go there where your friends are gone.
No, my lord. We never visited those places,
No, you should visit now
my lord. And
and come back. Then we'll go send you home. Yes, what you say?
And actually, he was badly beaten. my lord.
Died.
Right.
They are involved.
no,
From statement is
Statement of independent witness.
independent.
my lord. The kindly
And
see,
not a case of
Subhash Sutru, my lord, kindly see, this Subhash Sutrudur, who is the appointed, my lord,
Hmm.
his bail was considered and this honorable court.
After arrest.
No, 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 my lord, AB, my lord. This was the interim bill granted, my lord, and the case is,
Then P02 was not there.
no, my lord, and kindly see the subsequent order also. My lord, kindly- They have filed their petition after my petition, my lord.
When is the next date fixed?
Next date is, my lord, kindly see the next order, my lord. This is 12/10, my lord, and the next date fixed on 24/11, my lord. Case is still pending, my lord. Kindly see the order I have placed, my lord.
It's a case of rejection.
Hello?
Let it be on 24/11.
My lord, kindly.
No.
Because, my lord, puja, because of considered puja, my lord. Because we are the family members.
Puja has created this problem.
My lord,
Had you
we-
not been celebrating, you would not have faced this problem.
Actually, all were drunk.
Huh?
All were.
still puja, my lord. Similar consideration, my lord, kindly.
No similar consideration when city is there.
My lord,
I would have rejected this order right now. If there is an interim on the ground that there is a couple and all, first they have granted. In cities, there.
My lord, kindly. But similar
No, don't
consideration
say kindly.
after consideration-
Don't say kindly. Kindness, there is no question of kindness.
My lord, actually, we are not present in the occasion.
The witnesses are saying
No, my lord, we are the
that
visible
will be
vendors now,
decided
my
later on.
lord, we are
Please
not
this
present
with
in the.
on
24/11.
24/11. 20 4/11/2020. Because at that point of time, it was not 302. Along with PM report and PM report. Please list this matter along with AB 3193/2020.
But still,
Then it was 307. That's why we considered.
my lord, it was they are not present, my lord. Kindly consider, my lord, the interim prayer, my lord. The FNM request person is granted interim, my lord. And now he is moving,
FNM will go inside.
my lord,
That is for sure.
more,
If
my
I
lord,
am here,
these petitioners are not at all involved, my lord. Because,
we'll see that. One court has not granted interim. And you might have shown my order also.
my lord,
So, is not it?
My-
Because by that time you move this application, it has his character is changed. When I granted the interim, character was something different. It was raw. Now it is cooked. So, yes, next case. The person is in. You can send and come.
But in this case, my lord, I have taken the director to for my plan, my lord. He is ready for DNA test. Here, he is ready to for DNA test, my lord.
He is ready to.
DNA test, my lord.
It is a duty of the investigating officer.
And your lordship has.
Okay, we are giving interim protection. Appear before him. Get your statement recorded,
Lord.
and we'll record that he is also inclined to get a DNA test done.
Lord.
We will make his submission. We are not passing anything.
Only interim, Lord.
Only interim,
Only.
not final. We'll see. Present is an application under Section 438 of the Criminal Procedure Code for granting pre-arrest bail to the petitioner, namely Swenso, in connection with Bihali PS case number 101/2023 under section 376/306 IPC. Full stop. The allegation in the FIR is that why 30 why it was 302.
306, sir.
Okay, suicide. Okay. 30302. From the FIR, it is seen that the deceased was carrying a fetus in her home. And it is alleged that it is the present petitioner who fathered, who is the man behind that pregnancy. And due to such unwanted pregnancy, the victim was compelled to commit suicide. However, such allegation is refuted by the learned counsel for the petitioner, and on instruction, he submits that he is ready and willing to get his DNA matching done with the fetus if preserved by the investigating authority or any DNA testing has been done. Considering such submission, as the petitioner is protected till the next determinable date, the following petitioner shall not be arrested, subject to the condition that he shall appear before the IO within a period of 10 days from today, and IO may take necessary. IO may do record his statement and do the needful, as the petitioner has offered voluntarily to have his DNA sampling done. Is this matter?
We'll return the case diary. Lord.
Return the
I'll call for the update
case diary we return back and be produced with an up to date case diary on give a last letter
28/11.
28.
My lord, this court.
Doubtful is this, whether the investigating officer has done his part. Otherwise, this court could have
My lord, for-
other ingredients definitely will be required. What was the
Abatement part is whether it is there or not.
that
my lord, for the petition, my lord. The petition was interim bail, my lord. Yes, appeared and this is.
CD is there?
It is there, money appeared.
Not necessary. Okay. Cooperated. CD reveals that his custodial interrogation is not necessary.
Interim bail.
Interim absolute.
My lord, in this case,
Hmm.
I have some submissions, my lord. My
You are on
lord,
interim.
only interim only 3%. My lord, I have put some colored photos and I have 32 photos have been sent by the boy. Some photos I cannot show before you. Some photos kindly see. Such a romantic love. Also kindly see.
Now, where is the FIR? Let us see.
Yeah,
We'll
FIR
go to
will-
the romance later on. Let
Okay.
us see the
Phase 12.
Hmm.
Phase 12.
21 is the FIR vernacular.
Vernacular is 20. My lord, it is tutored by some AMSU member. Now that is but they are afraid of making AMSU as party. And listen,
This
it
is
is the
item 21. Okay, page 21
21 is the affair.
FIR.
It is tutored
Just
by
let me
AMSU.
kindly tell me, because this matter I have not taken up earlier. That's why I am not remembering and I do not know anything. Let me see the FIR.
FIR.
How many petitioners?
Petitioners are 5, my lord.
5. Tell us
No,
who are the
My
petitioners.
lord, one is the lover of that.
No, tell us who are the petitioners.
I am
We'll
saying.
come to the love affairs later on.
Then two is the sister of one.
No, we'll go to later on. Who are the accused petitioner here?
Yes, that's
Mohidul?
Shahidul Islam petition number 1. Mohidul Islam.
Mohidul is P1.
Yes,
Then
and Taslima is his
P2.
sister, own sister.
No, we'll come to the relation later on. Please
Yes.
tell us who are the petitioners here.
That two brothers.
We don't want the relation. Who are the petitioners in this FIR?
Yes, in this affair,
Total 4 numbers. All are petitioners.
no, 5 numbers. All are petition.
All are petitioners.
Yes.
Okay. Now tell us the relation.
Yes. Now, my lord, Mohidul Islam
Hmm.
and Zahidul Islam are own brothers.
Mohidul, Taslima and Zahidul are siblings.
Yes.
Who is Lal Mahmud?
Lal Mahmud is the father of Mohidul and the other, that 3 person. Father.
Okay, Lal Mahmud.
Yes.
Okay.
And 5 number petitioner is the husband of petitioner number 2.
Husband of petitioner number 2. That is son-in-law of Lal Mahmud.
Yes, Lal Mahmud. Now, Lordship, kindly see.
Any relation with him? All are Mahmud.
Mahmud, where is Mahmud?
Yes, Lal Mahmud.
No, sorry. Client relationship after that. Now, Lordship, FIR is tutored.
Just let me go to the FIR. Yes, Purva.
Lordship, first, my lord, kindly peruse the order dated 59/2023 of the General Court. 59/2023.
Hmm.
And the second page notice, and the second, third page. So they are 1 and 5, they are in, bail already rejected notice.
1 and
1 and 5.
Interim that is.
It is not mentioned in interim notice. It is said that accordingly they are prayer for them, then rejected. It is not mentioned in interim notice.
From the foregoing paras it appears because in this
Taslima, Jahidul, Lal Mahmud are granted.
Granted.
well, I don't know, foregoing
So it is
paragraphs
not
are
stated
No,
that
I'm
in-
saying that.
directly rejected without going CD. But CD was called for matter. Then if well, CD was called
regarding other accused person, I submitted lordship, they have appeared a statement recorded lordship. The main allegation is against the accused number 1 and 5, whom lordship already application has been rejected.
Arhat Mallad,
What is her statement?
Her statement is, my lord, that is very important.
Mallad, before that, Mallad, I want to close your lordship to certain document.
If you
Para-
are having some relationship, lordship, you will definitely not make this acquisition.
No.
They are against the two person, lordship, this allegation. ये अपने order track पर हो रहा है।
I do
I do.
Mahmood, you'll have to go to that court.
Mallad, for a
Spec-
moment, lordship, let me say this to your lordship.
No, we are granting this, he is also state that there is, these three interim we can make absolute.
Well, they have
But
appeared.
others, you have to file an application, maybe by mistake, but order is an order,
That is,
is not it?
yes, that is.
I cannot interpret that this is a
Actually,
typographical error or it's a fault of stenographer. I cannot say. That is to be said by the death court only.
liberty may be kept off.
It is not required, but it is
Not required. You have
No,
already,
even then, because that the motion is still that was done.
motion itself, we also dismiss sometime. We'll just the present application, the prayer of anticipatory bail so far relating to the accused petitioner number 1 and 5.
1 and 5.
Accused number 1 and 5 are petitioner number 1 and 5.
My lord, my lord.
Huh?
My lord, I am-
1 and 5 was rejected on the motion day itself. However, the petitioner number 2, 3, and 4 were granted an interim protection. Peruse the case diary. it is seen that the petitioner have cooperated with the investigating authority and there is no such specific material for custodial interrogation of the three petitions. Accordingly, the interim order passed
15-9.
in respect of the petitioner number 2, 3, and 4 are made effect. Petitioner that
Yes,
that I have already
is
said that
implied.
rejected.
That is implied. That may not be.
Case,
kindly
case
observed.
diary.
Okay.
You take your photo.
That is my weapon.
Huh?
That is my legal
This,
weapon.
this will be your next annexers.
Yes.
Second time.
It has come later on. That is why I could
Yeah.
not attack.
Yes.
My please, your lordship.
Yes.
Like, I am a student, your lordship, 19 years age, your lordship. The allegation, your lordship, is 14, your lordship. There is no rape, your lordship. 354A may be there, your lordship, but that is bailable offense, your lordship. May prefer some protection, your lordship. It was called for.
Not restrict, madam.
What is the age of the victim?
Major, your lordship, 19,
Both are 19.
same class.
Is-
But there is a problem, your
City
lordship, both are
Huh?
different caste, your lordship. That's the problem. There is a love affair. The boy visited her near house, same village, your lordship. Both are resident of. Just affair lost, your lordship, just bring out love village.
City is not here. What to do?
2 days already taken my friend, your lordship.
You cannot say puja also.
Well,
Or your puja ground is also not there.
On 18-9, it was called for.
When?
Only one date, my lord.
When?
My lord,
Vacation? 31 days.
May prefer some protection, your lordship. After becoming student, your lordship, 19 years. Very young, your lordship. The age is also dependent. It's a love affair, your lordship. When the affair,
Difficult to believe.
yes, my lord.
Sometimes difficult.
nothing happened, your
Much
lordship.
of false
Attempt-
allegation
Ah,
nowadays, my lord.
Many
Very
cases,
difficult. my lord.
false allegations.
Yes, my lord.
Young boys are inside 2, 3 cases and police are so prompt to file charge sheet in these
Yes.
cases.
religion not different, this is the issue. Nothing is.
But prima
Yes,
facie
14
from the FI, it seems, my lord, it was
354 is a bailable offense.
Can you have on 19?
Yes,
19.
19.
We'll see on.
Look.
If it is not record, we'll see.
Bless.
My lord, this is the land dispute between the brother. Phase
Why
9,
then, why have you come here, land dispute?
My
Go to
lord.
the civil bench.
my lord, due to this land dispute, later, my lord,
Out of land dispute, what happened?
the accused number 5, my lord, it is alleged in the FIR that accused number 5 attacked my lord, informant. And my lord,
City is
Yes,
there?
city not taken.
on the last date also, my lord, city was not there.
My lord, let it pick on 19 also.
19.
Okay.
Yes, Mr.
Yeah.
Khan.
Hello, this is a substitute case of
Hmm.
allegation under section 366A.
366A.
Hello, kindly, there is the 164 statement that is page 18.
When 366A, even if say that or consent, nothing is there.
Nothing is
Nothing
there.
must happen, that's all. Page 18.
I have flag mark.
Hart. Mr. Khan, Barnet Council for the also Hart. Stands for Barnet Additional Property. The scan copies call for has been produced. Peruse the same. From the material available in the case record, scope is of the peruse the material available in the case record. Also peruse the 164 statement of the victim. So from perusal of the said statement, there is no ingredient of prima facie.
Correct.
There is no ingredient of what is the section kidnapping.
366A.
No, no, 366 is a punishment. And what is the kidnapping definition? Kidnapping of a minor definition, which was that main section, substantive section. No prima facie material under 20 is fine, and no allegation of any sexual assault has also been made.
365.
365. 365. Considering the matter in entirety, this court is of the view that petitioner has made out a case for grant of bail. Accordingly, petitioner be allowed to go on bail on furnishing of bail bond of to the restriction of
CGM, no,
no, not CGM.
my lord,
It's not committed
no.
Huh?
Not for
to the
Case
to the
21.
to the restriction of CGM knockdown for furnishing of bail bond with the following condition.
Obliged.
Since POXO is not there, no allegation, 366A will not come. Kidnapping is something different. I reach a case of discharge.
Our statement is also doesn't show anything. Well, here we will require up to date city matter.
You require up to the city, okay,
Immediately after because
immediately after. Okay. Any interim? Interim.
item 42 is the interim.
In
Item 42,
42, interim to continue. 43, no interim.
43 BA
PA. Immediately after.
On
Give it
7.
7 11.
problem.
The 438 application.
Well, 44 simple injury.
Simple injury. Peruse the case diary. And also peruse the injury report. Considering the materials so far collected, this court is of the view that no custodial interrogation shall be required for for further investigation of the case. Accordingly allowed. Record statement.
I recorded.
Huh?
But I am not on interim.
You are
I'll
not
appear.
That's why.
Fine.
Go and
That's why I'll appear.
record your statement and other conditions. Dispose of.
Obliged.
Report the case, my lord, page 11 with the IR. Offense under 53.
Yes.
CD received.
11,
How many petitioners?
2 petitioner.
Two. Who are Afazuddin.
Ansar Ahmed,
Ahmad Borbia.
Afazuddin and
Ansar Ahmed and Jasimuddin.
three.
Two petitioners, page number 2.
Okay.
Ata
Afazuddin and Ansar Ahmed.
Ansar Ahmed and Jasimuddin.
Jasimuddin.
Then three.
No, at present 2 petitioner.
No, accused are
Accused
four.
three.
Accused four.
Accused
Who are the petitioner?
Petitioner for Ansar Ahmed and Jasimuddin Borbia.
Ansar Ahmed and
Jasimuddin.
3 and 4. Accused number 3 and 4.
Mine.
See,
My lord.
see the psychology of
Psychology. My lord, the pictures are not involved, my lord. They are the owners of the phone. Local villagers, my lord, on that night, my lord, they attacked, my lord. And even they tried to protect them.
It's not believable, my lord.
And
Phones are
during-
there and the local, then
During
others
my
will come and kill.
Go there and come back. This is not a case.
My lord, during
Man is skill of what is the ground? Stealing some fish from a pond.
My-
You are the owner of the pond.
my lord, with all respect, lord, whatever in this case, my lord,
And villagers will kill him, you will not.
You will not.
You will sleep
No.
inside your quilt, a quilt, and will not come out and see that who has stolen, who has beaten. Rejected.
all right.
For the material group, okay, implications, implicated material.
May I please?
Yes.
My lord, the effect of this case, my lord, FIR case number 11, my lord. The Assam Grameen Bank, my lord,
Hmm.
the petitioner herein
Hmm.
was the agent of a particular team of JLG, my lord, means joint liability group, my lord. What happened, my lord?
Hmm.
My lord, very first paragraph of the FIR, my lord,
Hmm.
second paragraph, that on the request of the one of the customer of the bank, his accused number 1.
Just give me a minute.
Yes, yes.
Just give-
FIR is
Yeah,
very
FIR.
confusing, my lord.
Yes,
May
yes.
I explain, my lord? Because, my lord, this petitioner
Hmm.
and another person, that is Azizur Rahman, they have some dispute in the monetary transactions, my lord. That they are from the, my lord, the Grameen Vikas Bank, my lord. What they are a joint liability group, my lord. The other
They-
person,
They have been granted loan.
yes, they for the loan, my lord.
agent one.
It is the case of the, my lord, that my lord, the person who has received the amount, my lord.
Hmm.
They said that he has given 8 lakhs for giving loan, but this petitioner has not given loan to other 3 persons, my lord. So, my lord, they dispute crop up, my lord. Then what this petitioner done, my lord, he transferred some amount to the account of the third party, my lord. So, from this third party
This
account.
bank official.
Yes, from the third party's account, my lord. That is the case. Your lordship will see, my lord, page.
My lord, may I request for the FIR, my lord, because it's clear in the FIR, my lord, paragraph 3.
Second paragraph is the, my lord,
FIR
from
is clear
whom
on that
to
one.
whom, why it is transferred, my lord.
Just give me a minute.
Yes.
Who are you?
My lord, Fakrul, my lord, Islam Borgul.
Fakhrul Islam
Yes.
Borkuya. What do you do? You are a bank employee.
No, my lord. The agent of a particular team of the bank, my lord,
Okay.
particular team of the bank. He has nothing to do in the bank. Second paragraph is very, my lord,
What
important.
is JLG?
My lord,
It is a
joint liability group,
Joint
my lord.
liability group.
The meaning is that, my lord, some persons, my lord, take loan from bank, my lord, and the petitioner,
You
my
are
lord,
agent.
yes, my lord,
Yes, sir.
to my lord, facilitate the loan amount, my lord.
Just a minute. You get a commission from the bank.
Yes, my lord, that is for the state, my lord, team, my lord. The second paragraph, my lord, on the request of the
Just a minute.
Yeah.
Just a minute.
yes.
People saying payment. Page 12, second paragraph of the FIR, my lord. That is
Hmm.
the main.
Ah. These two officers transfer from whose account this amount?
My lord,
This
this
is-
amount is transferred from one Abdul, my lord. And that was transferred to one Azizul, my lord.
No,
Azizul,
no, Abdul Manna Bhajare's case is that 7,30,000 is debited from my account
yes,
without my instruction.
without his instruction.
Now, what bank officers did is they took assistance from him.
Yes.
So they doubt that he might have transferred this, done this debit. Now from that day, he is absconding.
He's
He is not
absconding.
coming to the bank.
Bank.
Now this Manna comes and says that either give me the money or I'll commit suicide
Yes.
in your bank.
Yes.
These two person thought that instead of doing this, let us transfer this amount.
Comment, my lord, they brought the media and all,
Okay.
human cry was.
Now
This
this
is
7 lakh, who is the victim of this 7,30,000?
Well, these two officers have given from their own account. So the situation was such that, my lord, there was a crowd.
this is the
The
second
media
part,
also
my lord.
came in, my lord,
Okay,
And out
so
of-
they from their
from
account they
their,
have
from
given.
their account.
This is the second part of the event. First part is that, my lord, Abdul, from Abdul, the money was transferred to Azizul, my lord. So this
This
petition.
is yes.
So
Yes,
petition, RTGS.
And RTGS, there is always, my lord, there is always a requisition form, the signature is compared. So Hazari said that I have never done anything like. Then, my lord,
You doubt that this is the man who has created all this mess.
Because, my lord, he's a
Agent.
known associate, he's an agent of the bank.
Hmm.
He is a known associate of this Hazari
Hmm.
also. And, my lord, he has access to what happens is these branches. I was just explaining to my that the thing is that, my lord, in these type of branches, these people,
We
they,
know.
my lord, lordship knows, man.
I know
They-
that
they are
because there
asking-
are shortage
being a
of
class
employees.
officer, they keep this file here and there, these things happen.
Yeah.
My lord, this, and since that day, my lord, he became incommunicable. And he totally vanished. And he is the only person, my lord, who could have done this at that.
Your police will not arrest you
My,
because you are not at all involved.
my,
So there cannot be any apprehension.
my lord, nice, one thing, my lord.
Yes.
The third paragraph, my lord, itself, my lord,
Hmm.
says that on the request of that person, my lord,
Hmm.
the bank in the FIR, they mentioned that on the request of the customer, they have, my lord, transferred the money, my lord. It is not alleged that I have transferred, my lord.
No,
It is
this
clear.
is not the allegation. This allegation is this.
Yes.
That since this is my account,
Yes.
I say I have not transferred. While doing this, or suppose I pass an order where I rejected the bail, but ultimately it's in that bail was granted. Now I ask him to look into all this. I signed it. Now he knows my signature.
Hmm.
He made it because he is my private secretary. He says yes or no. I have just seen and signed it, or he might have signed it.
Fact is exact, my lord.
That is what happened.
Exactly.
You are the main culprit.
My lord,
And for that two innocent bank
My lord,
officers,
Yes, they-
That tremendous emotional.
my lord, for a moment,
not only that, otherwise you will recover it from them in a departmental process.
my lord, for a
6
moment,
lakhs, my lord. Bank
My lord,
officer, my lord, to pay.
Yes.
My lord, the customer's account, my lord, it is specifically mentioned, my lord, I give it my submission, my lord.
Yes.
That they had admitted that customer applied, my lord, he, my lord, in the third paragraph, my lord, on his request, my lord, they said, my lord, that the money is transferred, my lord, to accused number 3, my lord.
Hmm.
So accused number 3 is the beneficiary, my lord, and my lord, in the FIR mentioned, my lord, that they have, bank have approved the accused number 3, my lord, for collecting the money, but instead of, my lord, giving the money, my lord, he sent them demanding 6,01,000 legal notice, my lord. And my lord, that person, my lord, who instead of admitting this, my lord, mistake of taking the amount, my lord, he has approached this honorable court, and this court, my lord, granted him, my lord, interim protection, my lord. Kindly, my lord, this beneficiary, my lord, the third person, my lord, who has got the amount, my lord. 7,30,000 he received, my lord, and instead of my lord repaying them to the bank, my lord, he, my lord, sent a legal notice demanding another 6,01,000, my lord. And that person is, my lord, obtained protection from this honorable court, my lord. And the petitioner herein, my lord, will
Let us reject your case and you show the on 11 that we have rejected.
My lord, we will, my lord, cooperate with the IO, my lord. And my lord, since my lord,
Financial fraud, financial.
he is not beneficiary, my lord. The petitioner is not the beneficiary, my lord.
You will not be beneficiary. Account money will not be transferred to you.
Not my lord.
You will be benefited from accused number 3.
Not my lord.
Rejected.
That is not that big. My student.
Yes, for the informant bank.
Kindly pass over the matter.
Why?
We have to file one additional affidavit.
You want to file an additional affidavit. You have filed it.
No, we have to file. We have collected some certified copy now.
When?
After vacation.
After. It is there.
My liberty we even for sending the city.
It is there.
Yes, send the back.
Materials are there.
Details are there, man.
What is? What additional affidavit? Rejected.
My lord, this and we have collected one certified copy from
Give us.
Arti Passport matter.
Give us.
No, which
My lord,
needs,
whether it will help, my lord.
Give us.
We need some time, my lord. To
Give
file.
us. We are rejecting it.
My lord, we have to take.
Why you have taken time? This court also knows. All them for 3
Every-
times, 4 times I have seen this CD.
My lord,
Sudambor.
Yes,
Yes.
he
Give us.
was.
Give us the order. Tell.
my lord,
I will give you 5 more orders.
my lord.
5 more orders.
On 19, my lord.
No, not 19. Rejected.
My lord, that is the certified
Give-
copy, my lord.
give us.
Our contention is that, my lord, that
You cannot do like this.
my lord.
And you cannot seek anticipatory bail in a kind of harassment. Yes, give us.
My lord, yeah, we have collected one complaint petition has been filed by RT Bhaskar, my lord.
RT Bhaskar filed so far relating to the land dispute.
My lord, land dispute. And her statement was not recorded by the IO.
They will
And,
register. There is a dispute between A and B.
My lord,
Okay.
my lord.
You are C. And you have killed B.
My lord, we are the member of the club, my lord.
Ah.
And
You are the member of the club.
club, my lord.
And what are you doing? Dismantle this club.
Yes.
What are you doing? All members will come and beat people like mercilessly will be killed.
My
You
lord,
have rejected your president's bail.
my lord, we
You
are,
are the member.
my lord, with all
Rejected.
respect, my lord, with all respect, my lord.
Go upstairs. Go upstairs. I'll write a detailed order. Give me the.
A flag mark.
This is not a case for anything.
Right.
Not only that, you have beaten up the laborers. also.
They were witnesses that.
Yes, they have specifically named
Right.
3, 4. They could not identify others, but the wife has specifically named you. Huh? Return it.
Lost.
There is no doubt that there is a dispute in the land.
My lord.
There is no doubt that on that day, the victim and this laborer started working.
My lord.
But who are you? You are a local court.
But so far, our instruction, my lord, we are present there, but we are not participating.
What is
in
your
the-
business going to others' land where there is dispute?
My lord,
Where
that,
people are working, they specifically say that this 13, 14 from the club started beating us.
Yes.
After 2 days, I'll be able to specifically state what is the statement.
obliged.
Rejected. আগতে এই পড়ো
So I have trademarked also some of the relevant portion of it, that is search sheet and all this.
what is this? Nobody is here.
But that I was allowed some time to go to the scan copy.
Okay.
No, there are no such direct implication against this person, Lordship, but he was also present. And as part of postmortem report, Lordship, the deceased Lordship, he took drugs. And he also was sustained some injury, Lordship. At this stage, Lordship, we cannot say there is no implication against this person, Lordship.
But he may face
He was also present, Lordship. He was
let
also
him
present.
face the trial.
My lord.
Let the other
Let him-
staff will see.
May pleasure, Lord.
Yes, Mr. Bahmota.
My lord. The appeal was admitted, my lord, notice was issued.
Bail.
Bail so far as IAS concerned, my lord, because I am inside. And my lord, normally, my lord, once appeal admitted,
For what is the period of sentence?
lordship under 350 for maximum period of sentence 5 years, and that was imposed.
That was important.
5 years.
What is the statement of the victim?
Is LCR is received, my lord. This PW2, my lord. But there are full of contradictions, my lord. That's all it was. And appellant is a base method along with it. File.
Was this basis wife was examined?
Why, but he was examined as DW1. Because defense case was not actually
Where is 164 statement?
my deposition, my lord.
No.
154.
Okay, that is there, my lord, in the. Yeah.
Difficult, Mr. Bob.
Well, maybe
Yes.
it may be taken up at too much.
No, I have seen it. This is not a case for bail.
My lord, I may be,
We can prepone the hearing. You have given lesser punishment.
there is no scope for giving more punishment, my lord.
No,
because the
it's,
maximum is
you
not
ought to
here.
have been charged some against some other sector. Anyway,
My lord, maybe I may be allowed to submit, my lord.
Yes.
Whatever the statement of the victim, that is PW2,
I have read it, whole.
Yes, if such incident happens, my lord, immediately after the incident, she cannot feel physically comfortable. But she has stated deposed that she physically felt well. And the major contradiction, my lord, time of the incident.
Now show us that the contradiction.
Yes.
Why, how in a criminal procedure, how is to contradiction is to be confronted with her.
Yes,
Show us
Yes, my
in
lord.
cross-examination.
Yes, my lord. I have sorted out, my lord. It is there in the process, my lord. Even in C holds. PW2, my lord.
Hmm.
It is the victim, my lord. My lord, as per her version, my lord, the appellant came to her house at 4 to 5 p.m.
Hmm.
As per the version of PW1, it is her brother. As per his version, my lord, he came in the evening and handed over the accused to the police. So in the evening, the accused is in the police custody. As per version of PW3, her sister. As per her version, the accused came to the house of the victim at 8, started to the at 8:30, and it continued for 30 to 45 minutes, my lord. So possibly the accuser in the house of the victim till 10 p.m. So version of PW1 is that accuser is in police custody. Victim says that she came at 4 to 5, and PW3 says, my lord, the victim accused is in the house of the victim. And my lord, more so, my lord, reporting, my lord. So far as reporting is concerned, my lord. Reporting is concerned, my lord. Victim says, my lord, she reported the incident to her sister PW3
Dinner time.
at dinner time, my lord, because she left after the incident. She left to her sister. And my lord, PW3 says, no, on that day I did not know anything. On the following day I came to know about that. And victim stayed at her own house. She did not come to my house. And PW1 says, no, on the same day she reported, in the evening I came to know, and the accuser sent over to police. Whom to believe, my lord? These are, and there are some more contradictions, my lord. Not only that, my lord. So far as arrest is concerned, my
You
lord.
just go through
My lord.
how you have put this contradiction to the accused in your cross-examination.
My lord, my humble submission is, my lord. He is the-
Contradiction in a criminal case is to be placed confronted to the
my lord.
whose statement you want to contradict. You will have to confront it. Let's see, you have said this at this time, but so and so has said this time. And contradiction must be material contradiction.
My lord.
So far relating to the offense, that remains constant.
My lord.
We'll
That-
come back at
Whatever the weakness of the defense, and if there is any doubt, then the benefit should go to the defense side. Accused side. My lord, time of the incident, my lord. Time of the incident, my lord. There are major contradictions among the PWs, my lord. For the sake of argument, my lord, for time being, my cross part may be ignored. And for time being, my lord. Time of the incident, my lord. PW to victim says that the appellant came in between 4 to 5. So definitely the incident happened before 6. As per her version, my lord. PW1 says the incident happened before evening because he came to her residence in the evening and immediately handed over the accused to police. So as per his version, PW is the brother of PW. So incident happened before evening, my lord. Then, my lord, PW3 says, as per if the person of PW1 is believed, in the evening, the appellant is in the police custody. If the person of PW3, elder sister, married sister, my lord, if her version is believed, the appellant came to the house of the victim at 8
According to whom in the police custody? PW?
PW1.
One, okay,
Yes, in the evening, the appellant is in the police custody.
okay.
As per version of PW3,
Hmm.
her deposition, my lord, the accused came to the house of the victim at 8 p.m. Puja started at 8:30. It continued 30 to 45 minutes. So definitely, my lord, the accused is in the house of the victim till 9:30. So he is not in the police custody. If her version is believed. And my lord, these are my lord, my humble submission is major contradiction. Then, my lord, reporting when the incident was reported, because this is a serious offense, allegation. Reporting, my lord, if the person of PW2 is believed, then she reported the incident to PW3 after 9 p.m. at dinner table. If her version is believed, then, my lord, PW1's version that immediately after the incident, that is before evening, immediately after incident, the PW2 reported the incident to the parents. And accordingly, the accused was handed over to police. That is, he was handed over to police on 21/8/18. As per person of PW3, that the victim PW2 did not come to her residence on that day. She did not report anything on that day. She reported the incident on the following day. That is on 22/8/23, my lord. My humble submission is these are also major contradictions. Then, my lord, arrest of the appellant when he was arrested. As per version of the PW1, the accused was arrested on the same day, that is 21/8/2018. As per version of PW1. And my lord, admittedly, on 21/8/2018, no FIR was not, though he was handed over to police. As per, if his version is believed to be true. Then, my lord, his such person is supported by PW6. He is also another brother. That the accused was handed over to police on the same day, on 21/8/18. As per version of PW3, the accused was handed over to police on the following day. And at the time of handing over of police, PW1 was not present. But PW says he was present. As per version of PW4, the appellant came to the victim house on 21/8/18, 22/8/18, 23/8/18, 3 days consecutive. So if he was handed over to police on 21st, then obviously he is not expected to come on 22nd or 23rd. And as per version of IO, the FIR was lodged on 23rd. And the appellant was handed over to police on 23rd. My humble submission, these are major contradictions.
Yes.
Then, my lord, there is a motive to person the appellant because admittedly the age of the victim was suppressed. The FIR was lost none other than by the brother, elder brother. So he is expected to know the age of her sister. So FIR says her age is 15. Though medical report says
20.
Yes, my lord. And accordingly, she admitted also, and that is supported by
The child not convicted and
yes, my lord. But there is a motive from the very beginning. And my lord, there was a puja as per the version of the prosecution. But IO says no such article was found in the residence of the victim. So no such puja was held, my lord. Then, my lord, actually 354 is the tribal by magistrate actually. And normally your lordship is aware that the power of magistrate is normally 1 year or 3 years.
No, power of
sentence.
magistrate when charge sheet was filed in POCSO,
Yes, my lord.
candidate with apprehended
Yes, yes.
that it will be.
That is permissible, but this is not a case of POCSO.
This is not a case, they have
Yes.
not even.
So if he did not, if had it been tried by the learned trial magistrate court, then obviously, my lord, it would have been less than 3 years. Because his power is maximum 3 years.
I'm not.
Another submission, my lord.
Okay.
Now, as per section 29 of the CRPC. And my lord, when such a serious incident happens, and as per a person of PW2, the incident continues half an hour, obviously, my lord, there is maybe some symptoms in the medical report. But there is nothing in the medical report, my lord. And this is a bail, my lord. I am at present not pressing for acquittal. So, my lord, I may be allowed to rely on the judgment of the Honorable Apex Court. That is reported, my lord, 2009, PSCC 767, paragraph 20, 23, sorry, 16, 20, 23. 16.
But it says,
My lord, once appeal admitted,
Hmm.
normally, my lord, bail should be granted. May I read
yes,
the last paragraph? Then, my lord, paragraph 23. There are some parameters in paragraph 23, my lord. 2009. What's paragraph 23? In the present case, the appellant were on bail during the pendency of the case before the session court. The session court has acquitted most of the accused person after trial except the appellant. It is not the case of the other side that when the accused were on bail, they had indulged themselves in any offense. That is also in my case, my lord. Either under the provision of the penal code or themselves in any offense, either under the provision of the penal code or any other statute. It is also not the case of the prosecution there. When the appellants were on bail, they had either jammed the bail or they were anyway responsible for prolonging the proceeding before the session court. And it is also not the case of the other side that they would abscond or would not be available to undergo the sentence if the appellate court affirms the order passed by the session court. So bail was granted by the Honorable. My lord.
now you show us how you have brought this contradiction during the trial.
Yes, my lord. Because the examination itself says it. They are contradictory themselves.
Okay.
Ignoring my even cross examination part. Okay? That is their
So
evidence
according to you, they are even if
for the
they are-
purpose of bail, my lord, because we are not on
for the
bail.
purpose of bail.
Yes,
That
ma'am.
is also I'm going.
Yes,
This is
ma'am.
for the purpose of bail where you are already been convicted.
Yes, ma'am.
So we'll have to see the
That is why I am relying on this. This is also my case where the petitioner was convicted for 4 years. And already, my lord, I am in jail 9 months. My lord.
how many days you are inside?
My lord, earlier during my lord, investigation, my lord, I was in 45 days, and now it is 7 months plus, my lord, because from last part of the February, my lord, 2023, about 9 months, maybe, my lord. I am covered, my lord, by this judgment,
No, you are not covered. Their proposition of law is
my lord.
that if we say the ratio
My
in
lord.
this judgment
My lord,
is that no straitjacket formula
Yes,
can
yes.
be applied in exercise of discretion.
my lord,
Facts and circumstances of each case will be governed the exercise of judicial
my
discretion.
my lord. My lord, then I may be allowed to read paragraph 16. That is in case of murder case. It's a long paragraph, my lord. May I read, my lord?
Paragraph 16, my lord. Now the practice in this court has also in many of the high courts has been not to release on bail a person who has been sentenced to life imprisonment for an offense under section 302 of the Penal Code. The question is whether this practice should be departed from, and if so, in what circumstances? That is my lord, murder, 302. It is obvious that no practice whatsoever sanctified by uses and hallowed by time can be allowed to prevail if it operates to cause injustice. Every practice of the court must find its ultimate justification in the interest of justice. The practice not to release on bail a person who has been sentenced to life imprisonment was evolved in the high courts and in this court on the basis that once a person has been found guilty and sentenced to life imprisonment, he should not be let loose so long as his conviction and sentence are not set aside. But the underlying postulate on this practice was that the appeal of such person would be disposed of within a measurable defense of time, so that if he is ultimately found to be innocent, he would not have to remain in jail for any unduly long period. The rationale of this practice can have no application where the court is not in a position to dispose of the appeal for 5 or 6 years. It would indeed be a traversy of justice to keep a person in jail for a period of 5 or 6 years for an offense which is ultimately found not to have been committed by him. Can the court ever compensate him for his incarceration which is found to be unjustified? Would it be just at all for the court to tell a person, we have admitted your appeal because we think you have a prima facie case, but unfortunately we have no time to hear your appeal for a quite few years, and therefore until we hear your appeal, you must remain in jail even though you may have been innocent? What confidence would such administration of justice inspire in the mind of the people? It may quite conceivably happen. It is in fact happened in few cases in this court that a person may serve out his full term of imprisonment before his appeal is taken up for hearing. Would they just not be overwhelmed with a feeling of contrition while acquitting such a person after hearing the appeal? Would it not be an affront to his sense of justice? Of what avail would the acquittal be to such person who has already served out his term of imprisonment or any rate of major part of it? It is therefore absolutely essential that the practice which this court has been following in the past must be reconsidered. And so long as this court is not in a position to hear the appeal of an accused within a reasonable period of time, the court should ordinarily, unless there are cognate grounds for acting otherwise, release the accused on bail in case where the special leave has been granted. So, my lord, my case also, my lord, the appeal has been admitted, my lord. Then, my lord, immediately, my lord, I may be allowed to read paragraph, my lord, 20. Paragraph 20, my lord. I am reading, my lord.
Yes, yes.
This court in so and so, where the appellants had been convicted under section 307, read with section 34 of the Penal Code, and each was sentenced to imprisonment for a term of 3 years and to pay fine so and so. When they moved an application under section 389 of the Code of Criminal Procedure for suspension of the sentence of imprisonment, the High Court had rejected the application. This court, following the observation made in so and so, while allowing the appeal filed by the convict, had kept in abeyance the order of conviction also, my lord, not sentence. Order of conviction passed by the trial court till the disposal of the appeal filed by the convict, and had also directed the release of the convict on bail, my lord. My lord, this is my humble submission.
Lordship has heard my lord entire appeal, lordship. So my appeal can be disposed of my humble submission.
No.
Well, anyway, lordship, my lord, he is pressing the my lord state in an application, lord. My lord, he has to show my lord what the material that the learned trial court has, my lord, discarded, and then what are the evidence that trial court is not taking into consideration. Now, if your lordship will come to page number 33, lordship. It is the evidence of the my lord victim. The clear cut of lordship, my lord, although the charge has not been framed under section 375, lordship, but as far as section 375 IPC is a clear cut of section on the offense committed under section 375 IPC, lordship. But section 8 has not come because, my lord, during the trial, lordship, the trial court has found that the victim is not, my lord, below 18 years. That is why section 8 of POCSO, not, my lord, he was not convicted under section 8 of the POCSO Act. My lord, Lordship may kindly come to page number 52, Lordship.
Hmm.
My lord, that is the judgment of the trial court, Lordship, page paragraph 42. May I read, Lord?
Yes.
Now, the statement of the victim made as PW2 before the court has been very consistent with her previous statements recorded under section 161 CRPC and 164 CRPC. The evidence of the victim PW2 has been corroborated by the evidence of PW3 and other witnesses as discussed. Nothing has been brought out in the cross-examination of the witnesses to doubt their veracity or to suggest as to why they would falsely implicate the accused in this case. But if the victim statement evidence is, my lord, trustworthy and reliable, the Honorable Supreme Court has said the conviction can be made on the sole basis of the, my lord, testimony of the, my lord, victim, my lord, prosecutor. So let the, my lord, entire appeal be heard and disposed of.
IS stands rejected. Appeal be listed, detailed order will follow. Appeal be listed for hearing on given last week of October. November. Huh? 30 November. For final hearing.
In this case, my lord, the respondent number 2 has appeared. The LC has been received.
Mostly. Yes, what is this?
Respondent number 2, my lord, they have appeared, my lord, and the LC has also been received. My lord. So the
No,
matter
matter, I am
is-
the sole respondent. You know how.
Yes,
Sorry,
what is?
Well, this is for, my lord, and
And then
continue proceeding, my lord,
120.
maintenance.
Yes, madam.
You are legally counsel.
Yes, madam. My lord,
How
I am the wife, my lord, and he's not paying my maintenance, my
How
lord,
much?
since
You know, already
16,000.
there is an order, my lord, under the domestic violence act, my lord, 6,000 was being paid.
Hmm.
Additionally, my lord, 16,000 has been paid, my lord.
Now
by-
are you paying?
No, presently, my lord, I'm told, my lord, I'm in jail.
Why?
For taking bribe, my lord.
So probably, my lord,
Being
under the
a
PC
sub
Act, my lord.
inspector of Dokmaka Police Station. Till day before yesterday. maybe. But my lord, since my lord, there's been an order, my lord, on 1/11/2020, my lord, he is not paying any maintenance, my lord. And I have my lord 3 children, my lord, and with me, I have to
We are
maintain my lord.
taking up it in the last part of November. No interim order. He is inside jail. Let him come from the jail, then we'll get all the money and give it to him. Okay?
Then let it come up for admission. my lord.
Let it be admission. As matter is ready as regard service, list this matter on 29. We'll take this matter a little bit later. Let us finish up all the matter. After vacation.
No, Passover for the time. being.
No scope of Passover. We are waiting to one is Mr. Chaudhuri and that matter will take up after finishing the list. Today not possible. List
Immediate
this
after
matter
vacation.
after vacation, interim order pass or cancel.
Like.
That matter by mistake.
No, my lord.
What is it?
This is not quashing of a stating, my lord, purely civil dispute, private transaction between two partners invested in a, my lord, company. My lord. Report was for
Where is the crossing of?
my lord, charge sheet has already been submitted. FIR, my lord, page 17, my lord.
Annexure 4 is the, my lord, document he invested.
That electricity
Plot. Collection of bill,
collection of bill,
Bill.
you were partner.
Plot.
He invested.
he invested 50
Now
lakh.
you do, you collect
am-
the money from the public and you are not giving it.
No, we have to deposit before the authority. And authority give us commission.
Hmm.
Authority give us commission. And we partners will distribute the benefit.
What is the notice to the other side?
It was not
Hmm.
completed. As per office to 1210,
Office not,
1210, man.
where do you get office? Office not,
1210, man.
what is the next date fixed? Next date of the case,
Let's take it, sir. It was on 29/7, 27/9.
27/9. Take the
Yes.
instruction. The notice to the respondent number 2 was issued only on 5/10/2023. Await service report. Full stop. List this matter on. That's why I have asked what is the next date.
But just now I am
Okay, list this matter on, give the date, before the date.
Okay.
No, that's the way.
Yeah, please, Your Lordship.
Yes,
Is the matter in another matter?
Huh?
Because of some personal difficulty of my senior, they went. And
okay, on a prayer of the learned counsel for a petitioner, matter stands adjourned and be listed after.
interim order.
Interim order, give a date. After 22nd. Interim order, Pakar interim order, any.
They file affidavit
Reply, we have to file.
reply. Then my lord, matter may be listed for hearing, my lord. Hearing in the sense, my lord, admission hearing.
We are doing the admission hearing only
After vacation,
after vacation. Okay, this matter, this matter is ready as regard pleadings. List this matter in the admission column after vacation and on give a date last part of November.
29.
Any interim?
Yes, interim may continue.
Interim order pass.
All right.
Map your lordship.
Yes,
This criminal region petition is filed against the interim maintenance order dated 22/6/2023, which times at the last page and at the 12 of this criminal revision petition at page number 177, lordship. By the principal judge number 3, Kamrup Metro. In FT criminal case number 221/2022. Lordship,
yes, what is the wrong in this? This is
Yes,
interim order only.
yes, lordship, I am coming. Your lordship, I want to draw your lordship kind attention on page number 148
which is a copy of affidavit as disclosures of assets and liabilities by the petitioner in DB case number 76, 2021. Annexure 4, 10, page 148.
How many children?
No issue. Just after the marriage, the mental. And file many cases, 498A, 406, DP Act, then this FC criminal. Lastly, I have to file the divorce case, which is sub judice. So, your lordship, page number 148 kindly be produced. That's why. Page number 149 is pertinent. Column number 7. Page number 159. What she has claimed in DV case. Page number 159.
Yes,
Column number 7.
you contest that.
Yes,
This is an interim order only.
lordship.
We are not exercising our power.
To lordship.
A dismissal now or after vacation?
No, lordship.
Right now a dismissal or after vacation, tell us that.
No.
Which one? A or B?
No, your lordship kindly be heard on this point because why I am before your lordship.
You are a government employee.
Your lordship, I have
Admittedly, you have declared your income.
your lordship. That was not considered simply that. That's why I have kindly your lordship. Whatever order your lordship will pass, certainly should not affect in the final order. Number
Why
one.
should we exercise our power first of all? It's an interim order. Go contest everything. Why should we exercise
your
our revisional power against an interlocutory order?
That interim order is not legal one, lordship. How I am coming? Kindly be seen that what is her claim in the DV
Okay,
case.
you argue, you may have to pay a hefty cost. Yes.
After puja, then it be heard and if your lordship.
List after on the prayer and counsel for the petitioner, list after.
Much obliged.
Which date, madam? Or no date?
Noted.
Much obliged, your lordship.
Yes, what is this?
Lordship, may kindly produce this in copy, lordship. I have flag marked the start date and my lord, what is the evidence against, my lord, materials collected against him.
What is his name?
Imran
Rosdi.
Rosdi.
be a witness.
Well, he was also present there, Lord.
Present, but
They
he
consumed drugs.
should have been a witness.
Direct implications are not there,
Not
Lord,
there.
but my lord, he was present there and they consumed, Lord.
Perus and copy. Produce including the statement of the witnesses, allegations made in the charge sheet. Is seen from the charge sheet that there is no specific and direct allegation against the present petitioner in killing the his brother one. What was his name? Lalchan.
That may not be mentioned.
Majuto. It is, and some other persons are specifically investigated through the present petitioner was alleged to be present in the place of crime. Considering the matter in entirety, this court is of the view that petitioner has been able to make out the case of grant of bail accordingly. And allowed with all conditions, the bail during trial. All whatever condition related to the trial permission, everyday appearance, disposal. Yes, suggest us what to do.
Well, this date of occurrence of this case is 2694,
94.
and his statement was recorded under section 313 on my lord 282.
Just a minute.
Yeah.
Date of occurrence on
20/06/1994.
94. Statement.
Statement under section
This is
313.
this is accused 3.
Accused three.
Statement.
Statement recorded on 2nd of August 28/2007.
On that day, his
He
age was
stated that his age to be 28 years.
28.
So my lord, if we calculate my lord,
Where-
the date
when-
of occurrence, his age will be around
16.
15 years, 2 months.
15 years, 2 months.
months.
At that point of time, juvenile was 16.
Yes.
So he will be
He will
a
be
juvenile.
juvenile.
Now what proceed? What should we do now?
My lord, in that case, my lord, if court is satisfied on the, my lord, that is on this 313 statement, because that is the only thing that is before your lordship, then my lord, an inquiry is to be made by
Inquiry by the session judge.
station judge, because it's a station tribal case.
And what will you produce?
Then my lord, his first joining of the school,
Hmm.
that is one document, my
One
lord.
birth certificate.
Birth
Or say
certificate
At that
is-
point of time, there was no birth certificate. So school certificate.
School certificate first entering the school, man.
School. And then
If he-
if not available, then only other medical.
Other methods certificate.
And what will happen in the meantime? What will happen to the other case that we have already heard, kept it for CAV? Can we pass a judgment in part? This will be act applicable as 87. Isn't it?
86.
86. JJ 86.
Yes, sir.
And suppose we found him to be a juvenile. There is no scope for retrial at this stage.
Then he will be, my lord, produced before the juvenile justice court.
Then what will
Face the
happen?
trial.
Huh?
To face the, my lord, trial before the, my lord, juvenile justice. Or in merit also, if court decides, my lord, that for some point of time he was there in the jail and all.
But there is a judgment which unfortunately I argued knowing nothing. Bulu Ali versus State of Assam
Ulu Ali.
by a division bench. Similar thing happened. He killed his brother. And he surrendered. His conviction was 164 statement recorded. Conviction was there life. Then during course of hearing, already he spent almost 8 years. During course of hearing, the division bench by my Lord Justice Lokpur, then as he was, and my Lord Justice A.K. Goswami. And similarly asked for an inquiry. And after inquiry, when it was found that he was a juvenile, Court came to a conclusion, nothing will survive sending him for trial and all. You have taken it. Kindly see that
Yeah,
judgment
there is a my lord, Supreme Court decision is also there.
is in the
In the same line, what lordship had, my lord.
Buluwali versus State of Assam.
Yes, my-
I argued this case, unfortunately knowing nothing. 2013 something there,
it is a reported case.
reported.
Okay.
Just see it, huh?
My lord.
And if possible, give me a copy. I will pass the order later. If so before that we'll have an inquiry. And what is that judgment?
Here, my lord, Dharambir versus State of my lord, NCT Delhi.
Citation?
Year 2010 Supreme Court 1801. Here, my lord, all those procedure is there, my lord.
Where 2010?
2010 Supreme Court 1801.
180.
Dharambir versus State of NCT of Delhi.
Okay. We'll pass this order today. Let us, is it possible to give the Buluwali?
We will charge in the my lord if it is possible.
I have the citation. Okay, I'll try to have it. Okay, I'll give the citation. You give it to me.
If we get there in the my lord library, we will submit. I'm obliged, lordship.
Yes, last minute.
My lord, I'm sorry for the other day, my lord. Something happened
No,
because of
that
which, my
is
lord,
the problem. Though it has been said that we should do
True,
it,
true, my lord.
but problem is the network.
Sometimes network glitches are there. My lord, today I am here, my lord, my
IA.
lord, with also an IA. Why IA, my lord, before I start, my lord? Perhaps, my lord, the theory, my lord, when you commit a mistake, you try to hide it with several other mistakes. My lord, the answer is this particular IA, my lord. My lord, I'm just handing over to your lordship a list of dates. Just from the start of my arrest. The re-arrest which took place from when I am in custody, my lord, kindly sees. 28th of September 2022, my lord, I was taken in custody. I was taken in custody, my lord, and my lord, it was there, my lord. It was said that the original record could not be traced. That is at annexure 2, page 41 to 42. I'll just take your lordship across these with the pages. 41 and 42, my lord. My lord, this is the annexure, the order sheet. Original case record could not be traced out, hence the supplementary record is created. One Jogesh Kumar, New Delhi, mobile such and such was produced on Dhyan Singh, such and such in connection with CR case number 6 of 1996, arising out of GR case number such and such on the strength of transit remand order dated 26/9/2022, passed by the learned Chief Judicial Magistrate Baksar, Bihar. Also seen the application filed by Jogesh Kumar, New Delhi, praying to remand the accused to judicial custody. It is submitted that in connection with case number RC such and such, registered by CBI on 29th of October 1999 under section 20B, 25, 29, read with section 8 of NDPS, CBI submitted charge sheet against accused Dhyan Singh on 21st of October 2000. And at the same time, this court has also issued non-bailable warrant of arrest against accused against accused on 26th of May 2003 and 16th of June 2003 with the direction to arrest the accused Dhyan Singh and produce him before the court. My lord, I stop here. My lord, this word was read as compliance of section 82(2), the proclamation, the attachment and everything. And my lord, based on the prayer of my learned friends, my lord, 174A has been added to the charge. By conducting an additional charge hearing during this period, my lord, when this bail application, your lordship had granted them, my lord, that time to file their objection. And not only that, my lord, in their objection also, my lord, in paragraph, I will take your lordship to that, they have specifically said that we have made an application to show this. Now, my lord, 82, just for my own, your lordship has read it many a times, but my lord, only for my own sake.
NDPS.
My lord,
Chair. KRPC.
yes, my lord. '82, my lord, your lordship has got it. Proclamation for person about absconding. My lord, may I read? Proclamation for persons absconding. If any court has reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself, so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing such proclamation. My lord, there is nothing, with due respect. Never this has been done. My lord, I do not know what was the reading of the learned magistrate, but my lord, this was taken. My lord, just warrant of arrest being issued means, my lord, this is also done. Next, my lord, such proclamations shall be published as follows. It shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. It shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides, or to some conspicuous place of such town or village. A copy thereof shall be fixed to some conspicuous part of the courthouse. The court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper, circulating it in the place in which such person ordinarily resides. Now, my lord, let us come to the order. My lord, it's very unfortunate, my lord. My lord, may I take your lordship to the last portion?
Of the IA.
I am, my lord. My lord, page 54, it starts. My lord, may I just, before that, my lord, I have just prepared this list of dates only because of one reason. My lord, kindly comes to the second page of my notes of, first page itself, my lord, the date where it specifies 4th of May 2023. My lord, what does CBI do? Your lordship says LCR be called for and their opposition to be submitted only to ensure how the trial is to start. My lord, it is not my case I want a bail. It is the consequence of their conduct, my lord. They are waiting for more than a month, more than a year. So this is how it has developed into such a situation where we have filed this bail application. Now, my lord, what is it they have asked before the court below? The CBI has filed a petition before the learned court below to give certified copy of the following document. One, charge sheet or other document filed by HS Chowra. My lord, this is the original one. Next, my lord, case diary challan along with all documents. Third, list of witnesses along with statements. Fourth, list of documents along with documents. 5, complete order sheet. 6, prosecution evidence, if any. If any, my lord. They are the one who are the prosecutor. In order sheet number 7. Last, my lord, exhibited documents in court, if any, in the order sheet number 8. Well, this is what they have asked for. That is page 46. That's also recorded order, my lord. Page 46 of my eye. Just turns to this. Thereafter, I'll take your lordship to the next course of their action. My lord, this is the order. And my lord, the third paragraph from top. Your lordship has got it?
Which page?
Page 46, my lord. Annexure 4. So we filed, my lord, our criminal revision on 19th of March. On 4th of May, they go and file this, asking for this. And this is, my lord, the recording of what they have said. It is not that something we have got it from somewhere. It's all part of the record. Page 46, my lord. Kindly sees the third paragraph. This is the list. Thereafter, my lord, Rule 10 of Guwahati High Court criminal rules and orders were cited, and it was said that no, we will not be able to give it. In any matter, my lord, it is their pleading that the LCR is already there before your lordship. So this is one part. Next, my lord, kindly turn. That is 17, page
I-
48.
17.5.
17.5. My lord, here, my lord, kindly sees what happened. My lord, they took the certified copies out of the court, my lord, under the Guwahati court's rules, my lord. How can that be done? Forget about Guwahati High Court rules, my lord. Under no rules, my lord, this can be permitted. A lower court record is absolutely the thing which is there with the court. Court is the custodian. My lord, kindly sees the middle portion, that is after in terms 1, 2, 3, 4, fourth paragraph. On the other hand, PP and CBI Gaurav Bhatia has submitted that as per order of this court, the then DSP CBI HS Chopra also submitted that he took the original document of Tejpur PS from the court on 29/1/2000 under proper receipt memo on the strength of order of this court, and the originals of other departments were also collected by him for the purpose of investigation. However, while traveling by train from Guwahati to New Delhi, the briefcase containing all the original documents collected during, including from this court containing his personal belongings, were stolen on such and such. My lord, is this a duty which a prosecution is supposed to display? That also CBI, I'm asking to myself. Thereafter, while he submitted supplementary charge sheet on 20th of October 2000, the certified copies of the document made by him from the original record seized during investigation were filed along with the charge sheet, and thereafter, after hearing both sides, court framed charges under such and such.
No, no,
So-
just tell me, suppose charge sheet was filed subsequent to stealing of the document, on what basis charge sheet filed?
My lord,
On the basis of these documents, Lordship, the documents which has been received by CBI, that has been given by the court.
No,
Initially,
no,
yes.
see, just let me understand.
Yes.
You say that all the original records were handed over to the then Mr. Chopra by the court.
Yes.
For further investigation.
Yes.
Entire documents lost.
Lordship,
Now, from where have you got the certificate copy?
certified copy not, Lordship. The photocopies of all those documents has been kept in the file of CBI, Lordship.
Okay.
Those documents, not the.
Now,
basis of-
how do you certify those documents that this is the true copies of original?
Lordship, that is difficult, but even then, Lordship.
How will you convict this man?
Charge sheet has been-
Something must be charge sheet. You file charge sheet on the basis of an xerox copy, admittedly.
Yes,
admittedly, my lord.
that is there.
My lord, next admission kindly sees the following page, page 80. My lord, I tell your lordship, my lord, in this career of mine, this is a case which is really something to learn, because I have never come across this type of investigation on one of the best esteemed investigating authority, that is CBI, my lord. This is something very, it will be a, I would say, treat for my lifetime.
Yes, next.
My lord, page 50 kindly sees.
Okay.
Accused Dhyan Singh, this is order dated 11th of July. So, my lord, we starts, every movement of theirs starts from 19th of March. They ask for this document, then 11th July. They go and do this. Learned counsel Sri Gaurav Bhatia, appearing for CBI is present in court today and filed petition number such and such, narrating the brief backdrop of the case and praying to consider the available records, photocopy of the document furnished by CBI as supplementary record in the absence of original case record, which was lost and could not be traced out even till today, as reported by court. So again, it's an admitted fact that as on date, they do not have any record. Seen the said application and heard the counsel appearing for the CBI and for the state. Accused challenged the entire proceeding and order passed by this court before Honorable High Court under section 482 CRPC. But so far, no effective order passed by High Court has been placed before this court as on date. On the other hand, there is no stay order passed by the Honorable High Court. Therefore, there is no legal impediment in further proceeding with the case. Learned counsel Sri Gaurav Bhatia, appearing for CBI, submits that since accused absconded in the midst of trial, this court
What is the midst of trial? Without record, how trial was going on? What do you mean by
Trial with
midst of?
Lordship, supplementary case record has been prepared, Lordship. On the basis of that supplementary case record, trial was started.
Now, my lord, this court, by order dated 26th of April 2006, declared the accused absconded and kept the case filed till production of the accused before this court. So this is the submission of CBI. Subsequently, the accused was arrested by CBI and again produced before this court on 28th of September 2022. And since then, accused has been in judicial custody. Under the circumstances, the learned counsel Sri Gaurav Bhatia, appearing for CBI, submit that along with the existing charges on which accused has been facing trial, another charge that is under section 174A of IPC may be framed against the accused. Having heard the learned counsel for the CBI in consideration of the fact as is apparent before this court, the court found substance in the contention of the learned counsel appearing for the CBI. However, without hearing the defense counsel, it will not be in the interest of justice to pass any order for framing of additional charge, and accordingly, my lord, a date was fixed. The next date, my lord, we file our objection. That is the next following page 52. But my lord, this is nothing much. So I'm just turning my page. My lord, then my lord, on 11th of my lord, then on 11th, my lord, 11th, your lordship was pleased, my lord, after hearing us and them upon objection, my lord, that this is something, my lord, something has to be done. Now, when that something came and my lord, I sought time to come up with an application. Now, next comes the following page, that is 53. Accused Dhyan Singh has been produced from judicial custody. My lord, here, my lord, whether I will file any application or not, that they were not certain. So that is how it has been said. Though the case is fixed for framing of additional charge under section 174A, but due to pendency of proceeding in the Honorable Court, High Court for quashing the entire, no additional charge is framed today. It is informed by learned CBI such and such that the hearing of on the part of the prosecution has been concluded in the Honorable Court, and hearing for the other side will be on the next day, and then only effective order will come from the Honorable High Court. So, my lord, this was the representation. Next, my lord, is the final order. So, this is the date, my lord, before which we have already filed, my lord, our bail application, and my lord, they had been asked to file their objection, and after that, my lord, this is the date which comes. So, here, my lord, again, my lord, the entire thing is narrated, and then, my lord, coming to the facts, that is starting at page 56. Because these things, my lord, these are on provision of 82, 83 and everything. Now, my lord, may I start from page 56, the second paragraph?
Finally come to the page 56.
Yes. Coming to the facts.
Coming
to the facts of the present case and perusal of the supplementary case record submitted by prosecution, it transpires that the then special judge had observed the continuous conduct of the accused, issued NBWA and proclamation and attachment against accused Dhyan Singh on 17/10/2003. My lord, then this must be there with the court record. If that
Yes,
is
that
so,
is
it must be. My lord, let them produce that.
Court record is there, lordship. In court, okay, only lordship.
And EW is examined by the then special judge on 8/1/2004 and finally by date 26/4/2006. The case was kept filed against accused Dhyan Singh, observing the accused has already been declared absconded and further direction to the concerned officer in charge and SP to execute the pending warrant of arrest against the
Yes, but suppose, okay, we dismiss her all petition. What will you do now?
Trial will proceed, lordship. If lordship,
Proceed on the basis of
on the
what?
basis of the statement recorded by the IO, the photocopy of the statement of the witnesses, those photocopy statements has been supplied to them under section 207 during the framing of the before that, lordship. They charge were framed. They did not contest the charge, lordship. On 2002 till date, lordship, they have not challenged the charge. Charge has been framed. Trial begins. After examining two witnesses, lordship, CBI filed an application before the Honorable Supreme Court for rejection of the bail petition filed by them. So that has been rejected. Immediately thereafter, they abscond. That is the question.
No. All are suppose material. Suppose you have a seizure list.
Yes.
Forget about the statement.
Yes.
You will convict them on the basis of what?
On the basis of the statement, Lordship,
Only statement.
and Lordship, the
In a
document-
NDPS case.
No, Lordship. Certain things are there, Lordship, regarding the statement made by the officials of RTO. This is a case where on the basis of a chassis number, CBI investigated the case. The truck belongs to him. CBI investigated in such a manner that the officials of RTO statements were recorded. Those documents are in the original documents are in the possession of the RTO. Those documents, if necessary, will call, Lordship. Provision is there under section 91 of CRPC, Lordship, to call for the record, original record, if necessary, Lord.
Let us see your charge sheet.
Charge sheet, Lordship, perhaps not annexed, but I have a copy of the charge sheet, Lordship, taken out.
In revision, what have you challenged? You just
My lord, what we said is that, my lord, we are in custody. So either this be quashed if they do not have any document and if they cannot actually give the proposed date when they can start. Because I have kept it absolutely to your lordship, my lord, to see what is there from the lower court record. If at all, my lord, conscionable justice would be done, or I will be getting the benefit of Husainera Kapoor. My lord, this is one part of it.
Lordship, it
In
is
the
not
event,
legible,
my
Lordship,
lord, they can, my lord, to expedite. But my lord, it's 1 year and my lord, not a single document has been given which shows that they can start. Names of the witnesses, nothing, my lord. And furthermore, my lord, this is what is the extract which was copied, my lord. My lord, these are the documents which the person, the learned advocate who is there before the court below has found out that these are the documents which are there with the court. This FIR, my lord, is the initial FIR. That is of 1999, 1994, my lord. My lord, I have prepared a list of dates in my original application. So on getting information, that is 9/4/1994, that is the FIR copy of GD entry, my lord, it will be wrongly typed.
Lordship, may kindly have a look
Caesar
at the
list.
last page of the charge sheet is eligible, Lordship. List of witnesses and list of documents, we have annexed. Last page.
will get nothing. You say that you will get a copy of combined exact register of RTO Kohima dated 9/6/2000.
Will
Do you believe?
try, Lordship.
Huh?
It is very difficult because, Lordship, from court itself records are missing. I have doubt. From court itself, Lordship.
My lord,
It's just a
even
court,
today,
but
there is no record with the
Not
court, my
there.
lord, and 174 has been filed. Yes. My lord,
that
I
is
am
not
really
possible.
speechless on this.
No, what is that, Lordship? Even though, Lordship, admittedly, Lordship, there is no record. Let us examine the witnesses. Witnesses of RTO officials are there, customs officials are there, police officials are there. They will depose, let them depose what they depose.
You depose, let him be free.
There is a restriction under section 73, Lordship, imposed under the Narcotic Drugs, Lordship, and even by their own, I mean, to say petition, Lordship, they have annexed a judgment where they, Lordship, may kindly come to the petition, revision petition. They have annexed a judgment which reflected minimum half of the sentence he must be under the.
No, we are not on half of the sentence. We are on a situation extraordinary.
Lordship, that is right.
We are
I
not on this half or full. We are in a situation extraordinary.
Okay.
Where admittedly on record says that original records are not there. Which admittedly says as on date nothing has started. As on date.
Evidence was started, Lordship, way back in 2000. Evidence, Lordship. Therefore,
2000?
This 2002, Lordship.
2002.
It is because of his correspondence, Lordship, with the whole trial delayed.
When the document lost?
Document lost, Lordship.
When?
That cannot be certain, Lordship, because
No. Why? There is a specific order by the court on which date it was taken.
last order was, if you go by
where
the
is that
order.
47 or you have
My lord, that is the
2006.
page
No, no.
46, 40, my lord, 41.
Yes.
Page 41, my lord, of my IA, that is also a part of my original. Yeah.
See page 41.
No.
On 29/1/2000. Page
Number
48.
Yes,
Page
I'm
48.
sorry. 48.
29/1/2000 original records were taken for investigation or whatever
Yes,
purpose. From that, there is no record.
No record.
Then how trial commences?
Lordship, those records
Even
are
today,
photocopy, it will be treated as a secondary evidence, Lordship.
can that secondary evidence be taken like that? Where is your application for treating it to be secondary evidence?
Lordship, they have not challenged, Lordship. Cognizance was taken, Lordship. They have not challenged that order.
So they have not challenged. Therefore, a person can be convicted on the basis of
No,
thereof.
conviction will based upon the trial, Lordship.
Trial.
They may not
So
be.
prima facie, there is no material
Lordship, there
in
is,
your hand. Admittedly, you say that every time we have lost.
we have
What is the
lost it.
end result?
It
Tell
was
us.
stolen, Lordship.
You can argue many things.
Yes.
Many things. What is the end result of this?
Now
thing?
we cannot determine, Lordship. Now we cannot determine.
We can say right now, we can record it without original record and how a proceeding can continue. We are in a critical juncture.
Critical.
Vacation is there. I wanted to see the record. Whatever you are having it to have my satisfaction and pass an proper order. You are for how many?
My lord, again tonight I'll be flying back.
No,
Because,
no, you are flying back tonight.
my lord, if your lordship sits on 19, I can come.
And
Absolutely
Yeah,
at the
vacation
first
with
half.
festivity mood.
Because
19, it will not be possible. So many bails are fixed, it will not be possible.
my lord, 18 second half.
Difficult. But again, there will be a question of making it CAB.
No, your lordship is pretty fast. I have seen.
No, that fastness is here only. I will have to sit there to.
That is the gravity of the chair your lordship is holding.
That again, I will have to do.
Here, your lordship, I can speak anything to my heart's content depending on the merit of the case. But sitting there, your lordship has to be absolutely neutral and has to do.
I'll have to do justice.
Have to.
When as a lawyer, your job is to.
Easier.
Your
I tell your lordship it's easier because I tell your lordship I had an occasion to be an
your
arbitrator in
interest
few
is the
matters.
client's interest. My interest is the interest of justice.
Absolutely. My lord, I am aware because I had been an arbitrator in few matters appointed by court. My lord, while I was about to pass my award, the amount of oblivion I had to seclude my idea as an advocate and
Yes.
then I had to think. It's very difficult. I understand.
Because whatever we pass, this will have a ramification of all future cases.
Exactly. Because
And
this
it
will
is
be
a-
cited.
It is a special case. And let me be frank, after vacation, I may not be available for 2 weeks.
After vacation,
I may not be available for 2 weeks.
your
And a
lordship
person
there
is right under 21 is concerned. And it's a peculiar case. So we are in a, that's why I said I'm in a very critical juncture. Only three.
My lord, your lordship, I do not know whether this will be convenient and my lord, if your lordship feels that your lordship wants to give me a ad interim bail, my lord, on personal security as well as local surety. That is what my learned advocate friends are, as well my advocate on record is suggesting. They have taken specific instruction. And my lord, he will be meeting the IO if required, my lord, twice a week, thrice a week, whatever. Till my lord, your lordship is returning. And then your lordship take a call on the merit after perusing everything. If your lordship at that juncture feels, my lord, that this is an ad interim bail which should be rejected, I am open to that. I am not opposing because I really did not come up for bail. I said that I have a right to speedy, expedite and free trial, whatever might be. There has to be a proper record. You have to examine the witnesses whom you say should be alive.
See, problem is this. You are not concentrating on where you should concentrate.
Lordship, the record is the main thing, Lordship.
No. Yes. You are concentrating somewhere else, apprehending that this court may release it.
No, Lordship.
True.
No, Lordship. We are not on that,
Absolutely,
Lordship.
my lord.
I am
That
trying
is
to
the-
assist your Lordship from all
No,
the records, Lordship.
I'm not biased. I'm not
Lordship.
saying
Yes,
you.
Lord. Yes.
I'm not saying you.
Yes.
I am saying the prosecuting agency. they should, their focus should be somewhere and they are changing their focus to somewhere else. What is this 174-1A? Because only to prevent him from going.
No, Lordship. That is on record, Lordship.
I bow down
One
to
seventy
your
four
lordship.
only because of his
No,
abscondence.
that we understand.
And my lord, the objection, the only para they have highlighted is, my lord, that we have already preferred an application for additional of charge, and that is 174A. So that is there. That is also a part of their pleading. That is paragraph 12, page 109 of their opposition to the bail application.
You have filed an objection.
Yes,
The
my
bail,
lord.
Lordship. Yes, IA has been filed recently. I think on Friday, a copy has been served.
Yes, we have filed because we have come across all this lately. Every day new things are happening.
Lordship, I would like to place some judgment of Honorable Supreme Court as well.
We
as
are not deciding anything
Got
today, just listen to me.
Got
Let us do it properly. He is inside for so many days.
I leave it to your lordship.
We will
Let it
him-
be your
we-
lordship's
we
call.
Let him be for some time more.
Lordship may kindly consider my submission of it. The delay is because of his abscondence, Lordship.
No,
And
no,
the
we'll
whole-
come to that. We are not deciding anything today. We are not releasing right now also. Just I'm thinking over how to proceed in this step. It's a chaos.
I agree, Lord.
It's a chaos.
Because, my lord, here,
He
if
may
your
be-
lordship
He may
sees,
be an accused. He is an accused, not an convict.
I read.
He
my
is an
lord,
accused.
strange thing, my lord, here the entire original records first got lost. Thereafter, my lord, the case record also is not traceable. The case record
Lordship, the
starts
original
with,
case
my
record
lord,
has been
perhaps the
stolen.
original part of the
original-
case record is with your lordship's court, my lord. It has come because the other day my learned friend was pointing out that your lord, the LCR is already there.
No, no, LCR.
LCR not, like, photocopy of all the statement of the witnesses.
My lord, that is there before
No,
that got also.
Then, huh? He was an- huh? Yes.
Statement of witnesses, Lordship.
Well,
And
this
that
is
too,
what
Lordship,
is
it's a
there, my
scanned copy,
lord.
Lordship.
Lordship may kindly take the perusal.
The
I am
scanned
not
copy,
aware
Lordship, is
because
not
I did not
legible
had the
also.
chance of looking into it.
This is a record.
Lordship.
And
Statement of
record,
witnesses.
and record started on which date, do you know?
My lord, on the date of arrest. If I am sure of, because my lord, that's what my
Because
learned
we are-
advocate on record had examined. from
The
the learned
record
counsel's
started
appearance.
on 28/9/2022 when his
Supplement-
wife started
Bail petition.
bail, and there is no record.
Lordship, may I pray for Lordship one thing, Lordship. Let the vigilance, register vigilance may be directed to conduct an inquiry because case record is not found, Lordship. Why, from the court, whether it is, Lordship, good for the public, Lordship, whether case record has been missing for last 1 year, Lordship.
Okay, we'll pass an order. Let me think over it. I will see how to balance everything. May not be any bail today.
My lord, I am leaving it to your lordship because
not
my
be a
lord, I
bail.
do not want any order, my lord, which will be subsequently vacated. Because my lord, this is a very strange circumstances. My lord, once the
Let
case
us-
record
let us-
go
if you
based
have-
on
if-
supplementary
yeah.
Xerox copies or photostat copies, my lord, charge sheet submitted.
You have
Good,
given
bad,
what is
indifferent,
it?
nobody challenged.
They have not also challenged,
My
Lordship.
lord,
Let me first
Order of
record all the facts first.
my lord,
How
kindly
it's
do that.
proceeded. I will
Kindly do
record
that.
it and then see what to do. We will get the order uploaded day after tomorrow.
My lord, only with respect to IA, I was praying for stay of the operation of that order. Nothing more.
Lordship, then let us,
Because that has
give me
happened.
an opportunity to file an
No, no,
objection
this
to
is
the
very
IA, Lordship.
state.
You file an
Objection.
Yes,
file an objection ad interim we are saying it.
much obliged.
in the IA, you will give issue a notice to you,
Yes,
with a liberty to file,
reply to it.
In the meantime, we'll ask to stay. And otherwise, court will proceed on what basis?
Lordship, I have already made my submission, Lordship. Those statements are there, Lordship. Let them proceed as because Lordship statements were given to him, given to them. Copies, the original copies were supplied to them. They admitted and trial begins like that only. Now
Trial-
they after
trial
15 years,
begin.
Lordship,
Now
they are objecting to
Giving
the
a copy and continuing proving it in a trial,
Lordship.
it's on us is okay, NDPS, we understand.
Yes.
There are some specialities, some presumptions are there. But before that presumption, a foundational fact is to be laid down. From where will you lay down this foundational fact? Presumption is against them in certain cases, admitted. But the foundational fact, to have that presumption,
Absolutely, my lord. I bow down to you, Lord.
that how will you do that?
Lordship, this is not the only case, Lordship, against them. They were arrested by their whole, I will not say the whole family, his father, his brother was shot by PRPF because of this trafficking of
And
ganja.
acquitted, my lord.
And
That is what he has disclosed, my lord.
I don't know, Lordship, in this case also they might be acquitted because
My
of lack
lord,
of evidence.
There was some
This is
5
confirmed.
kg.
We'll concentrate as a sitting here, we'll concentrate the materials available before us.
Absolutely.
Not
I
both,
bow
not-
down to you. My lord, only one thing I was beseeching, my lord, when is your lordship returning? And then the tentative date, because I have to come.
You'll get the date day after tomorrow.
My lord, can it be a Friday? It's easier because I will be returning. By the time I return, it will be 11 o'clock. I'll sit in the chamber, I'll sleep at 3 o'clock. Because tomorrow I have a court again. Only that is the reason.
That same thing I did. I reached in the morning.
That I know, my lord. And I was just
My
seeking for
my
a privilege.
My flight was at 5:35 from Kolkata.
Yeah, that is the one which we have to take.
Yes, sir.
Any Friday, if it is convenient to your lordship, my lord, it will be.
It will be a Friday. We'll pass after vacation. We'll do it. And let us see. I'll go through each and everything. What objection he has filed.
My lord.
Your list of dates is there. I'll want to look into order, how the things proceeded, and how these issues can be resolved. Not only his custody.
And the entire,
Partner.
the cases speak for evidence, Lordship, on 3010.
3010.
Yes, Lordship.
Before that will. 3010 means
October.
further proceeding is stayed.
My lord, another thing, my lord, kindly specifies because I'm being told by the learned advocate who is there here from this court. My lord, most of the time, my lord, this matter gets listed somewhere else. Again, they have to mention and get it back. So kindly mentions that it should be marked as Pathad, my lord, in the cost list. Or else, my lord, is very difficult.
Okay, we'll pass the order. Let me go to sit in the chamber and go through
My lord.
everything, his objection and all. Huh?
Hmm.
Just a minute. Twenty-fourth.
24th November.
Ah.
March 1.
Thank
I shall be. And my lord, this bail and this may be tagged as one number, my lord, or else it's difficult. With it can be, my lord, that happens in our court. I do not know whether that's
Here
the
also
thing.
it's with it.
No, my lord, only thing is it is appearing with a different, in the cost list, different serial number.
No, this will be different serial number. With numbers will be different.
Very well,
That
my
is
lord.
the system.
But let the entirety, because my lord, I tell your
No, no,
lordship, I was a bit shocked. On the other day, my learned friend and went there. After your lordship had passed the direction for filing of objection,
No, no.
he went and said that, my lord, this application for bail was never heard of.
No, problem is this, there is a difficulty here. Because so far relating to criminal petition, this bench can take up.
Yes.
Okay, no problem on that. So far relating to bail, there is a special bench where special cases are there. So since I am taking up the revision, that's why this matter is sent to this court. Otherwise,
I am aware of that, my lord.
so therefore
Only
I will have.
learned friend, my learned friend had went and told the judge that no, this bail was never had, although my lord, your lordship had passed an order
What is
for
the
affidavit
difficulty
in
in
order.
arguing a case before the other court? There is no difficulty, all judges are same lordship. I don't know why. my
But
lordship
I
is
do not
insisting-
find it difficult
Then lordship-
because we were not
No, no,
applying for bail.
These are not important. These are not important things. These are law. He will think of his client, you will think of your client, and I'll have to balance that.
Absolutely, my
Yeah. Because it's peculiar circumstances.
Yes,
You'll have to look into how court record can be misplaced.
No.
Court record is not there. CBI record is misplaced.
CBI record was stolen lordship. During the stolen lordship, we have
Don't
filed,
say
no lordship, we have filed.
PSM.
My lord, this is
PSM.
Nothing can
something
happen,
that
lordship.
CBI should
Lordship
not
may
say.
kindly see, lordship may
Have-
kindly see
have
the
you ought-
conduct of the
you-
accused lordship.
You ought to have arrested that person. How can being a CBI officer, you can, your.
In train lordship, while journey traveling from Guwahati to Delhi lordship, in train lordship, it was stolen. They filed a FIR lordship. On
What
record,
happened? Final report.
that
Case
what
is
is the-
true, but no clue.
that is the difficulty. In all, most of the cases, this happen lordship. Want of evidence, the criminals get out from the. clutches
But
of the-
as a judge, what we can.
Yes, yes. I admit lordship. That is the difficulty.
That is the difficulty.
And the-
Suppose assuming that everything has been done, assuming for a moment that everything has been done at the base of our client.
And the voice of the person.
Then it is the CBI who could have unearthed this nexus. They are also sleeping all throughout.
No, lordship, we are trying lordship. We are trying from our.
That's
end.
right. That is not called try.
No, lordship,
That
whatever
is for
record.
CBI. Don't say that. Don't say that.
Anticipated.
So suppose assuming for a moment that who this missing of a document will benefit whom? The accused.
Exactly, lordship.
Yes.
Exactly.
So that
Missing of documents, all the documents, the case record from the. court.
understand. But
Will be
what have you done?
Give us a direction, we'll unearth. lordship.
Why should we give a direction? This
Power
is you.
Power
This
is
is you.
lordship,
Why?
we cannot directly entertain the record. I mean to say the inquiry.
No. You could have very well taken up a case by yourself that there is a conspiracy to do this original document. You make then officer and accused, everything would have come out.
Lordship, the case is pending in the court, lordship. Court is under certain observation. We cannot do like that. We have discussed this.
But missing you can do. Missing
Miss-
affair you have lost.
Missing, we have not, lordship.
Lost, but nothing happened.
Nothing happened, lordship.
That you could have.
Not- that
Your
is also
interest
of the
is
local-
not to go against your officer.
No, lordship. We
Might
cannot-
be. We are saying we are
lordship,
not.
We cannot investigate a case. In local police, we have no jurisdiction. DSP Act,
But
lordship.
it is a special case. You could have pursued. You have filed an FIR like
We
any
pursued
Tom and Dick and Harry. Okay, our record are lost. This is the affair before Bihar police. Method is there. And now who will suffer?
My lord, only one thing I was speaking, one indulgence, not this matter. Lord, I have got a new brief, my lord, item number 53 of the supplementary list. Your lordship has adjourned it, my lord, to 20th. My lord, since I will be here on
Who is the
20th,
other side?
my lord, I am not aware. Who is that?
Huh?
PP, my lord.
Okay.
My lord, I'll come back on 24th, that day I'll do it. I don't have it.
You have given on?
20th, my lord. Since I'm coming on 24th, my lord. Then
We
I
give
can
it on 2040 or not already uploaded because many orders I have already signed during the recess. And if it is uploaded, then
My lord, then in that even my junior will
then
mention and
we'll
get it.
make a
received.
mention on 20 and it will take
Ma-
up.
Much of it.
Anything left?